Any mention?
I beg to mention item number 5, Lordship. So after 2 weeks, Lordship, I pray for 2 weeks time, Lordship. Some difficulties today. The CRB matter.
No objection, Your Lordship.
Master.
Please, Lordship. Lordship, item 15 to 24, connected matters, my lord. These matters could kindly be taken after a week, if that is convenient.
It will be after 2 weeks, then, Your Lordship. Oblige, Your Lordship.
My lord, on a joint request, item number 4, my lord. Item number 4, my lord. Joint request. My lord. I'm appearing for the corporation here, my lord. Respondent corporate. There are two respondents, my lord, state respondent and the electricity corporation, my lord. I'm appearing for the corporation here. My lord, we are praying that if the matter can be taken out some other occasion, my lord.
This is a joint request, Your Lordship.
3 weeks, my lord.
Please, Your Lordship. Lordship, I beg to mention item number 12, Lordship. Lordship, arguing counsel is indisposed to me, Lordship. Lordship, after 2 weeks. After 2 weeks, Lordship. Lordship, same prayer for item number 10 on. Lordship, Mr. Marpana, Lordship is absent. I couldn't find him. He's absent, Lordship. I'll inform you later. I will do. Hello, Blanche.
Lordship, I beg to mention item number 11. Let it come after 2 weeks.
No objection, Your Lordship.
Yes.
Much obliged, Lordship.
Lordship.
May I please, Your Lordship? I beg to mention item number 13. My lord, the similar matter is still pending before the division bench, my lord. So I'm seeking some time.
Come after 4 weeks, Your Lordship. Oblige, Lordship.
Highly obliged.
Yeah, please, Lordship. I beg to mention item number 9. Uh, 2 weeks, my lord.
No objection.
Lordship.
Please, Your Lordship, I beg to mention item number 8, and for the private respondents, I'm praying if the matter can come up on the 4th of April. I've informed the other side as well, Your Lordship. Your Lordship, because the conducting counsel here, A.R. Pasa, he sought for 2 weeks' time. Your Lordship? Your Lordship, that was the instructions I received. The petitioner is R. Kharkrang. I've informed him, Your Lordship. Your Lordship, I've informed that it'll be mentioned, the matter. 2 and 3, Your Lordship.
One is taken.
Highly obliged, Your Lordship. Highly obliged, Your Lordship.
Lord, Lord, I beg to make a mention of item 3, Lord, and for this day, this matter is taken up after 3 weeks, 2 weeks, Lord.
His Lordship is supposed to either to file, whether to file the affidavit or not to file. That one instruction was there.
Pending for taking instruction.
Yes.
Because we have filed and amended.
Yes. Yes, Lordship.
Why not by next date? Otherwise, we'll proceed with the hearing.
Lordship.
Otherwise, why not perhaps affidavit? But then I do not want to give any commitment on that. Definite set of instructions.
It is pending for instruction, small instruction.
Kindly allow me 2 weeks.
Item number 11 and 11. Similar matter is pending in DB. POXO.
Item 11.
Item 11. Oh yes, he's the. You have mentioned.
And for 7, item number 7.
Oh, 7. Sorry, Lordship. 7. I apologize, Lordship. Item 7.
Yes.
Yes. 4 weeks, Lordship.
Lordship, may I please, Lordship, item number 10 is also similar.
Lordship, I've already mentioned.
I'm for the petition.
I've mentioned earlier, Lordship.
Yes.
Lordship, I'd like to mention item number 2, Lordship. Lordship, in this matter, this is regarding that construction of the road in Nongtrai village, Lordship. We were supposed to get instructions whether the funds from the SPV were utilized for construction, Lordship. Until now, I haven't received instructions yet, Lordship.
2020.
We have to file, Lordship. I'm still yet to receive instructions whether. No, Lordship, we have already filed affidavit. Arguments had gone, but then with regards to maintainability, but the question had arose from your Lordships whether the funds have been utilized from the SPV.
A derivation of fund from the SPV funds.
Lordship, after 2 weeks. I'd oblige.
May it please your Lordship, I beg to mention item number 14. I am for the respondent number 1. I'm praying for 2 weeks' time, your Lordship.
The petitioner, my lord. No. Oblige, Lordship.
Your Lordship.
Please, Your Lordship, I beg to mention item number 6. The conducting counsel is on sanction leave, Ms. P. Bhattacharjee.
No objection, your Lordship.
How long?
2 weeks time, Your Lordship. 2 weeks time. Oblige, Your Lordship.
Supplementary cost list, item number 1.
May it please, Lordship. Lordship, this matter concerns remission of sentence application, Lordship. What had happened, Lordship, was remission, Lordship. 19 years, Lordship. 302, Lordship. What had happened was I was arrested in the year 2006, Lordship. And since then, I have been in continuous incarceration, Lordship. And I was sentenced to undergo life imprisonment, Lordship. And the order, Lordship will kindly see, is placed at page number, Lordship. Annex 2, Lordship, page number 33. The type copy would be on the subsequent page, Lordship. Page number 34. I was sentenced by an executive magistrate, Lordship. That was at that point of time, separation had not taken place, Lordship. May I read, Lordship? Case record put up today. Accused Jyotil Boro produced before me. Hearing on quantum of sentence could not be done on last date, that is 27/5/2011, as I was on leave. Hearing on quantum of punishment is done today. Learned APP has made his submission. Learned Legal Aid Counsel is absent without stay. Since the conviction is under section 201 302 IPC, the court has only two options in the light of the accused's conduct during his internment in custody. He is sentenced to life imprisonment and also fine of rupees 10,000. In the event of his failure to deposit the fine amount, he shall undergo 3 more months of SI, simple imprisonment. The days spent in custody by the accused during trial is hereby set off, Lordship. Against this sentence, mark copy to all concerned, case stands disposed of, Lordship. I was never released on bail, Lordship. Since then, Lordship, I was in Shillong, Shillong district jail.
When did you file an application for remission?
Lordship,
Is it not that, Mr. Sulai, that state should automatically consider it?
Lordship, in fact, this, in portion of that pending litigation before the Honorable Supreme Court, the state has formulated a policy.
Policy, Lordship.
If Lordship can,
I have annexed it, Lordship.
Before I come to that, Lordship, it appears, Your Lordship, that the judgment of conviction and order has not been, it's not before Your Lordship.
Lordship, I have mentioned, if I may, Lordship.
You see, we will take a call after you take a decision. It is not, you have not taken a decision.
If, Lordship, for the moment, if Lordship kindly come to page 43. Kindly see the procedure to be followed, Your Lordship. Kindly come to para 1, Your Lordship.
Yes.
Para 1 is, Your Lordship, convicts eligible for grant of remission, premature release under the above policy shall be informed in writing by the superintendent of district prison and correctional home of their eligibility, and the acknowledgement of the convict is to be taken on such intimation. The record of all such intimation to eligible convicts shall be maintained by the prison authorities till remission is granted or rejected by the competent authority. Upon receiving such intimation, the convict shall have to apply for remission, premature release to the concerned superintendent of prison. The superintendent of prison shall, within 15 days of receipt of such application from all eligible convicts, forward the application to the Department of Prison and Correctional Services, Government of Meghalaya, through the Director, Inspector, so and so, along with this report, indicating inter alia the following points. So, Lordship, in my humble and respectful submission, Your Lordship, this writ petition is premature, Your Lordship.
Why?
Premature, Your Lordship, because the job of identifying the eligible convicts to be released, to be granted.
But then if they default in their job, then what happens?
Then, Lordship, he has to file an application first. Then come to Your Lordship.
When did you file an application?
Lordship, the first application, Lordship, would kindly come to page number 35, Lordship. I have filed 3 applications, Lordship.
Is it?
Yes, Lordship. I have annexed, Lordship.
Why Mr. Sulai says that he has not?
Lordship.
No, I mean, Your Lordship, after this policy. After this policy.
See, it's all right. You see, already
because there is now the policy has come into force, Your Lordship. So the procedure to be followed, Your Lordship, in my humble and respectful submission, Your Lordship, it should be as per the guidelines, the procedure laid down in the policy.
This application is before you. You can consider it.
Lordship, yes.
Does the policy say that the application filed before the permission came into force cannot be considered? You take instruction. This is something state should do of its own. If a person is eligible, why should you?
Lordship,
the minimum, Lordship, that incarceration set mentioned in the policy is 14 years, Lordship, and I've already undergone 19 years, Lordship.
I'll have instruction, Your Lordship.
That is what
at the same time also will.
There was a matter pending before Apex Court. What happened to this thing, Miss Colony? You must be knowing that.
Yes, yes. Some order has been passed, Your Lordship. Some order has been passed.
There was some matter.
Lordship has also been part of that matter. Now, madam, the recent development is that Honorable Apex Court has directed the High Court to take up the matters. So now the case which Lordship was.
But then matter is over. It is no more pending before Apex Court.
No. It's we'll have instruction, Your Lordship.
It's a small thing. Why?
Yes, if there is because application is there, Your Lordship, we'll take a call on that application, Your Lordship.
Can we take instruction then?
Lordship, yes.
Yes. Mr. Pandey, Lanak Council for the petition. Over in 3 weeks. Mr. Andy Shulai along with Mr. Andy Landry AG along with Ms. R. Colony. Landry G has appeared on as also appears on behalf of the respondent number of all the respondents. Will be there for all the respondents, isn't it?
Lordship, yes.
Yes.
Except 6, Your Lordship.
Stop let necessary instructions.
1234, Your Lordship. 1234. Meghalaya Legal Service Authority, Your Lordship. 56, Your Lordship. Because this is a step.
The learned AG to take necessary instruction in the matter. This after 3 weeks. Yes.
Lordship. Apply, Your Lordship.
I'll oblige, Lordship.
Item number 2.
May it please your Lordship.
Yes.
Lordship, this is a civil revision petition. My Lord, through this petition, we are attempting to highlight the fairly strange manner in which MACT Joy is conducting a claim application which is pending before it, my Lord. My Lord, I've taken the liberty of preparing a indicative list of dates because the dates are important. If Lordship kindly looks at the list. My Lord, in this matter, the notice...
You are insurance company. You are the
insurance company. The notice was received by insurance company on 23rd March, my Lord. Now, the problem in this case was that the policy concerned was from Delhi. So it took some time to locate that policy, verify that policy, and get that policy from Delhi. The next date in the matter, my Lord, was fixed on 12th of April. There was no appearance from our side. The second date in the matter was fixed on 31st May, my Lord. On 31st May, an ex parte order was passed against insurance company, saying that the matter will proceed ex parte against insurance company. Subsequently, my Lord, we entered appearance on the next date fixed, which is June, 6th of June. Subsequent to that, my Lord, on 11th of September, we filed an application to recall that 31st May ex parte order, my Lord. Most importantly, I would say, my Lord, on 7th of November 2023, MACT allowed us to file a written statement.
What happened to your application for recording?
It was still pending, my Lord. During the pendency of my application, my written statement was filed.
Before the ex parte proceeding order?
Before any sort of hearing or orders being passed, my WS was...
By the same officer?
By the same officer, by the same officer. So WS was accepted. Now my submission at this point is that the WS being accepted means that the court itself has nullified its own order.
Application of what law?
My Lord, because once there's an ex parte order, I cannot hope to go back and do something which had happened before which should have happened before the ex parte order. So once there was
Sangram Singh's principle.
Yes, my Lord. I'll just come to that also, my Lord, in a minute. So so my first submission would be that by accepting my WS, you have nullified your own order. You have rendered it not, my Lord, in a way. In any event, my Lord, the WS was filed, the matter proceeded, the parties took some time to try and settle the matter between themselves. It was a property damage to vehicle case. So they took some time to try and settle the matter. We appointed the surveyor. Survey report said, indicated a certain amount to be paid. They had an estimate with them which indicated a different amount to be paid. Parties tried their best to try and reach some sort of understanding, but unfortunately that no.
Why are before this court now?
What has happened is an order has been passed, my Lord, on 30th August last year. If Lordship looks at that order, no, before that, my Lord, I need to point this out. That settlement process had failed. That settlement process had failed. On 30th August, parties informed the tribunal that the settlement has failed. There's no fruitful outcome, my Lord. On that day, out of the blue, that petition we had filed the previous year for vacating the ex parte order was taken up suddenly, taken up for hearing, and an order was passed on that petition. That order, my Lord, is at page 55. Is the order. If I can take my Lord to the relevant paras, that is at para 14, page 58. I'll just take 2 minutes to read 2 or 3 paragraphs, my Lord. Para 14, yes. Page 58.
Yes.
At the bottom, my Lord.
Yes.
Para 14. In order to recall the order for ex parte hearing, the party has to assign good cause. This tribunal would not like to delve into the distinction between good cause and sufficient cause. It will be suffice only to record that sufficient cause stands at a higher degree than good cause. Ordinarily, the tribunal should adopt liberal approach in interpreting good cause or sufficient cause to ensure substantial justice is done. The cause assigned has to be has to pass the test of the party, cannot be blamed for his absence, and there is no negligence or lack of bona fide. The cause assigned by the OP Insurance for non-appearance on the date fixed on account of the OP Insurance had to confirm the policy from Delhi, and further the lawyer was appointed on so-and-so. In spite of the notice was duly received on so-and-so, notifying the insurance company to appear on so-and-so, clearly demonstrates inaction and negligence on part of the insurance company. As such, the cause assigned by OP Insurance cannot be construed as good cause.
What is the cause you assigned? What was your cause?
The cause was very simple, my lord. The policy concerned was from Delhi. It took some time to locate
But
that.
that is no reason for non-appearance.
My lord, I'll just address this point also, if Lordship allows me to finish this order, my lord. Last paragraph. The order fixing the case for ex parte hearing cannot be recalled. Merely on asking, a case has to be made out for recalling, and the cause given should pass the test of being a good cause. The cavalier manner in which this application has been filed and reason assigned only manifests that the OP Insurance has not shown any interest in appearing on the date fixed. There has been negligence on part of insurance company. The application lacks bona fide. This application is devoid of merit, and such casual application should be deterred. It only delays the proceedings. Accordingly, it is rejected with cost amount of rupees 10,000. Matter shall proceed for ex parte hearing, so on and so forth. Now, my lord, there are two problems that arise from this order. That is apparent from this order. One, my lord, if lordship would have noticed from the list of dates, there was a delay of 2 dates, more or less 2 months in entering our appearance in the matter. Now, within those 2 months, nothing had happened in the matter, my lord. Nothing had happened. The other opposite parties, the owner and the driver, they did not appear. They are, in my instructions, they are yet to appear. In fact,
See, we are concerned with the cause, nothing else.
True, my lord. True.
It cannot get diverted. See, rightly or wrongly, an order of ex parte proceeding was passed against.
Yes, ma'am. Yes, ma'am.
Now, if you want to get it set aside,
yes,
you have to show a good cause.
Yes, my lord.
What constitutes a good cause? That is what is to be seen.
True, my lord. But this being an MACT proceeding based on a social welfare legislation, the law is quite clear on this, that there has to be some leeway, there has to be some flexibility. As I was submitting, 2 dates were missed by us. 2 dates were missed by us. Within those 2 dates, no heaven had fallen, my lord. If we had applied 2 years later, for example, then there
for interest of justice, court should have allowed it.
Should have
allowed.
allowed.
Issue notice, we will just see.
Very well, my lord. Also, my lord, the records may be required, because what has happened is we are not in a position to.
Records we will see, if required, we will follow. Record may not be required. We will just see if other side also may not press for ex parte proceeding. True. If they do not oppose your application, then
very well. Very well.
Pardon, Mr. S. Tintal, on a counsel for the petitioner. Issue notice, the returnable in 3 weeks. Steps for service of how many respondents?
Just one, my lord. Sole respondent.
Step for service of notice upon the respondent to be taken within 2 days. List after 3 weeks. Yes.
Obliged.
Item number 3.
Wait, please. Lordship, state is before your lordship.
Yes.
Challenging the order of the commercial code dated 19th March 2025. The issue, my lord, if I take your lordship to the order before taking you, the issue in this case is, my lord, that there was MOU signed between the state health department and the respondent, my lord, for running of the diagnostic facilities in 2019. Though MOU was for 5 years, the MOU required that government should give the land to the respondent, on which diagnostic facilities will be run by the respondent. So there were certain commercial arrangements entered between the state and the respondent. This was the structure. The respondent.
The diagnostic center was run on your land,
on my land, in the premises to be given. If your lordship will see the clause of the MOU straight away at page 79. This is, and your lordship will also mark one more aspect, that this MOU was at page 79 is the MOU dated 21st June 2019.
Yes.
In this MOU, Suraksha Salvia Global LLP, your lordship kindly mark the name because it is also very important for my submission. Suraksha Salvia Global LLP is the LLP, my lord, which entered into the agreement with the government, my lord. because name is bit confusing, my lord, because I was also having this MOU, my lord, and the requirement responsibility of Department of Health and Family Welfare is at page 80, my lord, page 80.
Yes.
The responsibilities of Department of Health and Family to provide the land for setting up the super specialty diagnostic center, my lord, to provide a space and funding for construction of such infrastructure pertaining into the above described diagnostic center, provide funding and required capex facilities. So there were certain responsibilities which were assigned to Department of Health and Family Welfare under the MOU, and responsibilities of private partner you lordship will find at page 81.
Okay, right now we are concerned with what?
So what has happened, my lord, that I terminated the MOU, my lord.
After the expiry of the...
No, before expiry, this MOU was for 10 years, my lord.
Yes.
I terminated the MOU because under the MOU, diagnostic center was being run in one of the wing of the civil hospital, that is Pasture Institute.
Yes.
Pasture Institute, it was being run. We tried to amicably settle the matter because we wanted the building for the purpose of a medical college, for which we have made the submission in December of 2024 to the NMC, my lord. Because for current academic session, we have to make the application to NMC to start the...
Your MOU is dated 2019.
19. So
and
this...
when the proposal for medical university came?
We submitted in December of 2024. December of 2020. That application you will also find at page 191.
That's all right. See, like...
Yes, so the issue is that we submitted the application. There were some lapses on their part, and
but then your initial MOU was for 5 years.
Oh, no, 10 years. MOU from 2019 to 10 years. The clause is 10 years.
So
I terminated it before the period of the MOU was over.
No, but then you need it now for the purpose of
medical college. And
but then your initial thing, if it was for 10 years,
yes, my lord,
and your proposal for medical college came,
yes, my lord,
in 2020,
yes, my lord,
you could have intimated them then and there that
yes, we have intimated. We tried to settle this matter amicably.
These are so far sexual.
Yes, I understand, and rightly so. No, rightly so.
In 227, how much we can go.
I understand that is what I want to place the legal issue also, that under 227, what is the scope and why are we here before your lordship? So we terminated it. My friend challenged the decision of termination under section 9 of Arbitration and Conciliation Act, because there is an arbitration clause in the agreement which say. So my friend filed a petition. I will place that section 9 also. My friend filed a section 9 application before the learned commercial judge. The section 9 of Arbitration and Conciliation Act provides that pending arbitration proceeding, interim relief can be granted for in the matter. That is the scope of section 9. Now the agreement has already been terminated. The agreement. We have a copy, madam.
Because
yes. So under
Advocate General, this court is
no,
not very,
no.
not very
I will assist. I will assist you, lordship, because we are all student of law every day. We learn every day new thing, and so your lordship will kindly see section 9 of Arbitration and Conciliation Act. A party may before or during the arbitral proceeding, or at any time after making of the arbitral award, but before it is enforced in accordance with section 37, apply to a court for appointment of guardian for a minor or a person of unsound mind for the purpose of arbitral proceeding, or for an interim measure for protection in respect of any of the following matters: the preservation, interim custody.
Anyway, they have the power, so there is no problem with the authority.
No, the power is, my lord, only with the power is coupled with the specific relief act, because the court has power to pass order in terms of a specific relief act.
Apparently, it has the power. Whether
No,
it has been
it has no power. No, it has no power to stay the terminated agreement. It has no power because the agreement I have terminated, my lord. They are questioning my termination order. That will be examined by the arbitrator whether my termination is good, bad or ugly. That is the under section 9. I will place the authorities on that.
See, that is so far as the you see, like the technicalities
No, is
are
it,
concerned.
is
But
it,
then the
if your lordship will see,
the-
kindly read with me section 9 subsection 2, my lord.
one thing is that
yes, my lord.
the court has the power to
No.
pass interim order.
Yes, my lord. Interim order of what nature or what kind? That is the
That is
issue.
okay,
before.
but then the power it's remains.
The law bars that no power the court, commercial court, cannot pass the order for staying the termination of the agreement. That is the law bars. That is my humble case is that law does not authorize you to pass the order of stay of the termination, because that is the final relief which will be granted by the court. Law gives you that there will be preservation, protection of your interim rights.
But here the interim order.
Yes.
Is it?
Yes,
the
my lord.
nature of staying the termination.
Yes, my lord. That is, and if you also will see one more provision of law, a specific relief act, my lord, because law has to be a specific relief act. Kindly see this. Yes.
Yes.
And kindly see the provision section 20. 20H, my lord. Sorry, specific relief act. You also will find the schedule at the
20H.
20A. You also at 20. I am sorry, 20A.
Yes.
Section 20A.
Yes.
Is kindly see 20A, the top. No injunction shall be granted by a court in a suit under this act involving contract relating to an infrastructure project as specified in the schedule, where granting injunction would cause impediment or delay in the progress or completion of such infrastructure project, my lord. So if there is a infrastructure project, my lord, no,
but then you said that the termination
and
of agreement
yes,
cannot be.
and I
That
terminate
says so.
I terminate the agreement for building the medical college, my lord.
So these are the factual aspects.
There is no dispute so far as this project is concerned. I assert, my lord, that I terminated the
Please
contract.
be conscious of one thing, that year 227 is
I will.
unless you point out there
Yes.
is a gross error of law.
Yes, my lord.
It is not that you say like as an ordinary error of law.
Yes,
This
my
court
lord.
is
Gross error of law. Because what is law says that you cannot grant injunction in infrastructure project. 20A is clear, my lord. And kindly see one more provision. 20A and 41. The 20A, no injunction shall be granted. There is a prohibition in law. My case is for provision in law. And your lordship will see section 14D of a specific relief act. There is another prohibition. 20A, then 14D also your lordship may kindly see. The following contract cannot be specifically enforced, namely, 14.
Yes.
A contract which is in its nature determinable, 14D. So this contract cannot be, if the contract is determinable, the remedy for the respondent is seek compensation, take compensation, my lord. The following contract cannot be specifically enforced, namely, a contract which is in its nature determinable. Commercial contract, my lord, it is determinable. So 14D is my first provision. Determinable contract cannot be enforced. Second, in infrastructure project there can be no injunction, and my lord, and kindly see 41, my lord, section 41. And subsection HA, my lord.
Yes.
An injunction cannot be granted when HA, if it would impede or delay the progress or completion of an infrastructure project or interfere with the continued provisions of relevant facilities related thereto or service being subject to matter of such project, my lord. So injunction cannot be granted, my lord. And then your lordship will find the schedule, my lord, schedule attached to the act, my lord. And your lordship will kindly see the table. At serial number 5, social and commercial infrastructure. Lordship got it, the social and commercial infrastructure in the schedule. And the top of the schedule, if your lordship will see, section 20 capital A and 41 HA, my lord.
Yes.
And then your lordship will kindly come to serial number 5, social and commercial infrastructure, and see your lordship hospitals including medical college. So my first submission is
whether these provisions,
yes, my lord,
can be used.
Yes, my lord. That's
to throw somebody.
Yes, my lord.
From the
I will
place
the
before
second,
the.
Yes, my lord. Yes, my lord. Now the second, there are two aspects
So
of the matter.
supposing.
Yes, I go.
You enter into memorandum of understanding with
Yes,
me,
my lord.
and it is for 5 years.
Yes, my lord.
Then suddenly after 3 years you
Yes, my
come and give me a notice saying that you see we have a public project to implement.
Yes,
you are right. You are true.
I'm grateful, my lord, for putting this question, because this question has to be there. This question has to be there whether I can exercise this power or not. I have a right to exercise this power or not.
Maybe very like a kind of layman
No,
question.
no. This is
then,
no,
yes.
no. These are the pertinent questions. As a court, these questions should be put to us, because these are the questions which are dealt by the learned judge also in her order. So that I have to deal with this issue. So first, I will take that part also, my lord. I will take. What is the scope of the power under section 9 of the Arbitration and Conciliation Act, my lord? Your lordship is dealing with challenge under section 9 of the my lord. There are two powers. One is that the plenary power of the writ court under 226, where your lordship has got wide powers to do that. And one is under the special act, power is being exercised by the commercial court. Power is being exercised, and so the width and power of the commercial court will be within the ambit of section 9. This commercial court is not a writ court which will go into the issue of whether it has power to annul the wrong done by the state government if it is a wrong, because the commercial court has to act within the ambit of the statutory provisions, my lord. For that, my lord, I will that issue has fallen for, because it's an opportunity, my lord, for me also to revisit and to go back. So if your lordship will see one judgment of Adhunik.
Adhunik.
I am giving a copy.
Yes.
Adhunik steel, my lord. Sorry, copy. This is one of the leading judgment on this aspect of section 9 application and the role of specific act in granting interim relief. This is the leading judgment on this aspect of the matter. And if your lordship will see because your lordship has raised the issue of the power and jurisdiction, and this was the issue which was there before the Honorable Supreme Court also, and kindly see paragraph 11, my lord. If your lordship kindly see paragraph, because that paragraph has been, this section has been quoted, and if I can take your lordship to paragraph 8, my lord.
Yes.
There was a considerable debate before us of section 9 of the Act. Paragraph 8, your lordship.
Yes.
According to the Learned Counsel for Adhunik Steel, section 9 of the Act stood independent of section 94 and 39 of Code of Civil Procedure, and the exercise of power thereunder also not trammeled by anything contained in the specific relief act. Learned Counsel contended by way of an interim injunction, court could pass an order for preservation or custody of the subject matter of arbitration agreement, irrespective of whether the order may be passed was in mandatory form or in prohibitory form. The subject matter of arbitration in the present case was continued right of Adhunik Steel to mine and lift the ore to surface on behalf of O&M Private Limited, and until the arbitrator decided whether O&M Private Limited was entitled to breach the agreement or terminate the agreement, and what would be its consequences. The court had not only power but duty to protect the right of Adhunik Steel conferred by the contract when approached under Section 9 of the Act. Learned counsel emphasized that what was liable to be protected in an appropriate case was subject matter of arbitration agreement. Learned counsel relied on Mustil, my lord. These are the leading proposition, my lord, and kindly come to paragraph 10, my lord. Learned counsel for O&M Private Limited submitted that Section 9 leaves it to a party to approach the court for certain interim measures, and it enables the party to pass order by way of interim measures of protection in respect of matters enumerated therein. Neither this section nor the Act nor anywhere elsewhere has provided the conditions for grant of such interim protection, leaving it to the court to exercise the jurisdiction vested in it as a court to adjust whether any protective measure is called for. In this context, neither the provisions of Code of Civil Procedure nor the provisions of specific can be kept out while the court considers the question whether on the facts of the case any order by way of interim injunction or protection should be granted. So the court had necessarily to consider the balance of convenience, question whether at least tribal issues arises if not the establishment of prima facie case by applicant before it, and other well-known restrictions on the grant of interim orders, like the principle of a contract of a personal service would not be specifically enforced, or that injunction would be granted in certain circumstances as envisaged by section 14 and 41 of specific law. Thus, it was contended that the grant of an injunction by way of interim measure to permit Adhunik Steel to carry on the mining operation pending the arbitration proceeding, notwithstanding termination contract, was not permissible in law. Paragraph 11, my lord. It is true that section 9 of the Act speaks of the court by way of an interim measure passing an order for protection, for preservation, interim custody or sale of goods which are subject matter of arbitration agreement, and such interim measures of protection as may appear to the court to be just and convenient. To grant of an interim prohibitory injunction or interim mandatory injunctions are governed by well-known rule, and it is difficult to imagine that legislature, while enacting section 9 of the Act, intended to make a provision which was divorced the accepted principles that govern the grant of interim injunction. Same is the position regarding the appointment of receiver, since the section itself brings in the concept just and convenient while speaking of passing any interim measure of protection. The concluding words of section that the court shall have same power for making order as it has for the purpose in relation to any proceeding before it also suggests that normal rules that govern the court in the grant of interim order is not sought to be just jettisoned by the provision. Moreover, when a party is given right to approach an ordinary court of the country without providing a special procedure or a special set of rules in that behalf, ordinary rule followed by the court would govern the exercise of power by the Act. On that basis, it is not possible to keep out the concept of balance of convenience, prima facie, irreparable injury, and concept of just and convenient while passing an interim measures under section 9 of the Act. The power and jurisdiction of the court arbitral matter has been a subject matter of discussion. Relationship between the courts and arbitral tribunal have been said to be swing between forced cohabitation and true partnership. The process of arbitration is dependent on underlying support of the court, who alone have the power to rescue the system when the one party seeks to sabotage. The position is stated in so and so, and then your lordship kindly come to paragraph 16 of the judgment, my lord. Injunction is a form of a specific relief. It is an order of a court requiring party either to do a specific act or refrain from doing a specific act or act either for limited period or without limit of time. In relation to breach of contract, the proper remedy against defendant who act in breach of his obligation under a contract is either damage or a specific relief. We have two reliefs, either damage or specific relief. The two principal varieties of specific relief are decree of a specific performance and injunction. The Specific Relief Act 1963 was intended an act to define and amend the law relating to certain kind of specific relief. A specific relief is a relief in specie. It is a remedy which aims at the exact fulfillment of obligation. According to Dr. Banerjee in Tagore Law Lecture of Specific Relief, the remedy for non-performance of duty are compensatory and specific. In the former, court awards damages for breach of the obligation. In the latter, it directs the party to default to do or forbear from doing very thing which he is bound to do or forbear from doing. Law of specific relief is said to be, in essence, a part of law procedure, for specific relief is a form of judicial redress. Thus, the Specific Relief Act 1963 purports to define and amend the law relating to certain kind of specific relief obtainable in civil court. It does not deal with the remedies connected with compensatory relief except as incidental and to a limited extent. Right to relief of injunction is contained in Part 3 of Specific Relief Act. Section 36 provides that preventive relief may be granted at the discretion of the court by injunction, temporary or perpetual. Section 38 indicates when perpetual injunctions are granted, and Section 39 indicates when mandatory injunctions are granted. Section 40 provides that damages may be awarded either in lieu of addition to injunction. Section 40, so entire Act 41 provides for contingencies when injunction cannot be granted. 42 provides for contingencies when injunction anything contained, particularly clause E, no injunction can be granted to prevent the breach of a contract, the performance of which would not be specifically informed for granting an injunction to perform. Thus, the power to grant injunction by way of specific relief covered by Specific Relief Act. In Nepa versus so and so, learned single judge of Madhya Pradesh, High Court has suggested when moved under Section 9 of the Act for interim protection, the provision of specific relief cannot be made applicable since it is taking interim measure under Section 9. The court does not decide on merits of the case or right of the parties and considers the only question of existence of an arbitration clause and necessity of taking interim measure for issuing a direction. When the grant of relief by way of injunction is in general governed by Specific Relief Act and Section 9 of the Act provides for approach to the court for interim injunction, we wonder how relevant provisions of specific relief can be kept out of consideration. So what the Honorable Supreme Court, my lord, in my humble submission says that a Specific Relief Act has to be applied while examining the relief under Section 9 for grant of that.
Way.
Yes, my lord. So my submission is that if you are considering the,
is it not that like we get this the cardinal principle for granting the injunction?
Yes,
that is what is to be followed.
Yes, my lord.
Nothing else.
Yes,
you
my
did
lord.
not say that.
Yes, my lord.
The Section 9 basically
would
be
yes, your lordship is right.
Subject to Section 20, 14 or 41 of that specific relief.
Yes, my lord. So the requirement, your lordship is right, that cardinal principle is prima facie case, balance of convenience and irreparable loss. These are the cardinal principles, and there is a statutory bar where in certain cases you cannot grant injunction. Like in infrastructure project 14(1)(d), the injunction cannot be granted. If I take your lordship to the 21, because
no, that is okay. It means you are saying that the exercise of power under Section 9
yes, my lord.
of arbitration
yes, my lord.
would be subject to the provision of Section 20, Section 14 and Section 41.
Yes, my lord, because there is a bar in law. But if there is a bar in law, you cannot grant relief which law prohibits. The law, and that is what there is a series of judgment of Delhi High Court on identical situations which say that this kind of relief cannot be granted, which the relief has been granted under Section 9. And here two reliefs are there. What is,
if this relief cannot be granted, where the aggrieved party will go?
The relief,
where the relief will
relief of two types, my lord. The relief, if I am an aggrieved party and I am aggrieved with the decision of the government. So my remedy is that there is a breach of the contract, and breach of the contract has resulted in, it is a determinable contract, it has resulted in loss. He's lost because he was required to, he would have profited if the contract was allowed to run for 10 years. He would have earned X amount of profit if the contract would have. So if he has earned the profit, he is in, and he will prove that no, my termination is wrong, he will be entitled to compensation with damages or interest, my lord. His remedy is, nobody is remediless in law.
So it is not an irreparable loss.
It is not an irreparable loss. It is, and the law, when law says, because I can't go beyond law, nobody can go beyond law. Law says injunction cannot be granted, whether it is permissible for the court to grant injunction. Indeterminable contract 14(1)(d), it's because we are all creature of the contract or of the law.
But then otherwise it has the power to grant injunction if these conditions are fulfilled.
No,
in a matter,
he cannot.
In a matter, just a minute.
Yes, my lord. Sorry. Yes, sir.
In a matter where those stipulations made in Section 20A, Section 14D and 41HA
yes, my lord,
is fulfilled, then in such a case,
yes, my lord,
the courts exercising jurisdiction under Section 9 of the Arbitration Act
yes, my lord,
can grant an injunction.
the court can grant injunction if the section 9 is not in place, section 14(1)(d) is not in play, 20A is not in play, and 41H is not in place.
So what about the stipulation therein? So
So
supposing
there is, because this is the bar on the court that you will not grant injunction.
it is all right. So it's a matter of, you see, appreciation by that court whether the situations which
Yes,
are
ma'am.
mentioned in section 20A, 14D or 41HA exist or not.
Yes,
exist
ma'am.
or not.
Now the question.
Now, is it not that this is the court will have to? It is not that. See, it doesn't have the power to, like at all apply its mind under section.
No, I am not saying that court will not apply the mind. Court has to apply the mind. That
See,
I can't
now
say, my lord.
It means the ground which you are raising here in this court.
Yes, my lord.
You can raise it in appeal also.
The question, the section 9 is, my lord, section 9, the commercial court is not deciding whether the my termination is good or bad or ugly. Commercial court is not
deciding.
Because commercial court is only till the time it will be decided by the arbitration.
Yes, it's an interim.
So now the question is that in interim measure, can you do something which is barred by law? I put a question to myself. If it is barred by law,
No, whether something is barred by law or not, that
Now-
is for that court to consider, isn't
now,
it?
and if that court has considered it and it has not applied its mind, my lord, it is for your lordship to consider it under 227.
Just a minute. Now, the order which is under challenge here,
Yes, my lord.
it is otherwise applicable.
No, my lord.
There is
It
no
is
bar
not,
in it.
it is not applicable order. That is why we are in 227.
It is not applicable.
It is not applicable because under the
It will not come under section 13 of the commercial code.
no, it will, because it is an interim order, my lord. In similar matter, my lord, there was an order passed by the section the court. It was similar matter, interim order. Only final order can be challenged by way of appeal under section 13 of Commercial Code Act. And this your lordships have held the learned.
So, if say supposing in a matter where consideration has to be on the basis of the merit, it is an order passed under section 9.
Yes, my lord.
Where the party will go? The normal usual remedy is 227.
No,
there is no
the-
other
no,
remedy.
now if the order is final order is passed under section 9, then the remedy is an appeal before the final order, my lord. Against interim order, there is no appeal provided under the Commercial Code Act, my lord. And we were there. Is similar issue, identical issue has been decided by learned single judge. NTPC NTPC got an interim order, my lord. Against that, we got the state got the interim order for the commercial court here in Shillong, my lord. That was challenged by NTPC pending the final decision on in similar order, my lord, before learned single judge of this honorable court, after examining the law, held that the 220 against interim order, the NTPC judgment is there, my lord. I will place there is no appeal provided. So if there is no appeal, my lord, kindly see the judgment of this aspect, my lord, of 220, scope of 227 also, because that issue is there in Achyutanand Badya, my lord. This judgment of 1997, 5 SCC 76, my lord. If there is a remedy of appeal, I will go in appeal, my lord. Paragraph 10, my lord.
Yes. Yes, please.
The power of superintendence of the High Court under Article 227 of the Constitution is not confined to administrative superintendence only, but such power includes within its sweep the power of judicial review. The power and duty of the High Court under 227 is essentially to ensure that the court and tribunal inferior to the High Court have done what they were required to do. Law is well settled by various decisions of this court that the High Court can interfere under 227 of the Constitution in cases of erroneous assumption of acting beyond its jurisdiction, refusal to exercise jurisdiction, error of law apparent on record as distinguished from mere mistake of law, as your lordship said, arbitrary or capricious exercise of authority, or discretion or a patent error in procedure arriving at a finding which is perverse or based on no material and resulting in manifest injustice. As regards finding of fact of the High Court should not quash the judgment of subordinate merely on the ground that it is a finding of fact, my lord. So the question, the law is well settled, my lord. I cost of repetition I submit that interfere in erroneous assumption. If the law prohibits from giving you injunction and you grant injunction, then it is an erroneous, in my humble submission, erroneous assumption, my lord. Or error of law apparent on record. In my humble submission, there is an error of law on apparent on record because my friend's application.
So the submission will be that the subject matter was not adjudicable by the
I'm grateful.
By the court below.
Yes,
under section 9. That is, in short, that is.
This is my, and if it is not adjudicable and there is a bar and then interim relief is granted, my lord.
Overall your contention is that this is the one issue. This should not have been entertained under section.
That is my first and foremost issue. I'm grateful, my lord. This is my precise point. Now, second point which I wanted to show the illegality in the manner in which order is passed. I'm really sorry to say I should not have gone to that extent. But if you lordship will see what has happened exactly on the ground also, in the course of hearing also, my lord, kindly see that aspect is also giving me trouble and pain also. Why? Because ultimately we have to go in accordance with law, whether state or by private party or at the courts also. We have to follow the law. Now kindly see what has happened, my lord, because not in this case, I am not concerned with this case. There are a series of cases where interim orders are passed by the courts below without examining whether these three tests are met or not.
But that is all right. But then I don't think that will be adjudicable under 227. We are concerned with.
Yes, my lord. What I am concerned with, my lord, is this thing, that if the court below is passing the order or exercising the jurisdiction which is not vested in them, or in the manner
your case is something what this court understand is that the court has exceeded its jurisdiction. Rather, it has exercised its jurisdiction in a matter where it should not have.
That is the sum and substance. And kindly see, my lord, what has exactly happened. Kindly come to page 172, my lord, the first order of the learned commercial court, my lord.
So these kind of matters basically is not supposed to be kept pending for long, isn't it?
Yes, these are matters which
things. So
yes, and the strange thing is that if I can show my just 2-3 orders, my lord, if I can show, my lord, I understand that these matters should have been decided immediately without any delay.
Yes. Page
171 is, my lord, your lordship order starts from page 156. That is the first order obtained, or the first order passed by the commercial court on 12th February 2025, lord, in miscellaneous case number 1 of 2025, lord.
Yes.
156, my lord, and kindly see that 156 and the operative portion of the order, my lord, is at page 171. Now, therefore, this is ex parte order which was granted by learned commercial court, my lord. Therefore, at the bottom, page 171, my lord. Therefore, this court hereby grants interim ad interim injunction till next date, restraining the respondent from giving effect to the notice of termination dated 30th January 2025, and restrained from disturbing the possession of petitioner at the subject so and so in terms of notice of termination dated so and so. Petitioner. So then, my lord, the ad interim injunction was granted to the respondent, my lord. Then the matter was fixed on, my lord, on 24th matter came, my lord. Then your lordship will see the next order, 24th at page 173.
Yes.
24th, the CR put up before me, petitioner is represented by so and so and so and so. Seen the application filed by petitioner for extension of interim order dated 12th February 2025. Learned counsel submit the matter being be listed for hearing tomorrow. So we wait press for that, let the matter be hearing, my lord. No order was extended, but be as it may, my lord. Then 174, your lordship will kindly see the order. CR put up before me, so and so, my lord, he see. Then the relevant part, your lordship will find 4th paragraph. The learned counsel, respondent and petitioner both submit that learned counsel petitioner has touched upon the maintainability of application under Section 9 of Arbitration and Conciliation Act, which will have the direct bearing on commercial number 2 of 2025. Learned counsel of the petitioners has made a suggestion that issue of maintainability be as raised by respondent may also be treated as part of the main application. Learned counsel for the respondent submit he has no objection to the proposal made by the learned counsel for the petitioner. However, submit that in the event it is decided that application is maintainable, he would reserve the right to file reply in the main application of commercial case number so and so. As agreed by parties, the issue of maintainability is taken up for consideration together in commercial case number so and so. However, in the event of issue of maintainability is decided in favor of petitioner, respondent would have liberty to file. Learned counsel petitioner has prayed for extension of entry injunction till the matter is disposed of. So prayer was that the matter however, this has been objected to by learned counsel for the respondent. In the interest of justice, petitioner shall not take till Thursday, my lord. Lordship may kindly Thursday 27. My lord, kindly see next page.
Yes.
The learned counsel for the petitioner is heard, and then thereafter the hearing for reply for tomorrow has prayed for extension of till the matter is disposed of. Again, the second prayer is reiterated, my lord, that the disposed of. However, this has been objected to by learned counsel for the respondent. In the interest of justice, petitioner shall not take any coercive step till tomorrow. That is till 28th February, my lord. Now kindly see 28th February, my lord. The matter, my lord, petitioner is represented, respondent is represented, who prayed for...
Same order till 33.3.
Yes, my lord, petitioner shall not take till 3rd. Now on 3rd, my lord, matter was heard. On 3rd March, matter was heard.
Yes.
Finally heard. Now, learned counsel respondent is heard. Petitioner prays for certain replies. No, now because I raised the issue of maintainability of my lord, I was heard on 3rd, my lord, 3rd March, my lord, and I kindly see my note for a moment, my lord. Kindly see that page. 200, my lord, at 200, which was that I filed, my lord, my objection at 200, my lord.
Yes.
These are the objections, my lord. Kindly have a brief look on the objection, my lord. The instant petition is not maintainable as the petition has been issued by third party to the MOU. My objection was that this petition is filed by Suraksha Selvia LLP, which is not a signatory to the MOU. This is an independent jurisdiction.
Then who is in occupation of that premise?
The problem is that Suraksha Selvia, Lordship, kindly have this paragraph 1. Kindly see this, everything is displayed. The instant petition and the miscellaneous application have been filed instituted by one entity by name of Suraksha Selvia LLP. It is submitted that Suraksha Selvia is not a party to the memorandum of understanding 21 and the arbitration agreement contained therein. In this regard,
sought for any eviction, their eviction, saying that they are not a party of MOU and they could not have occupied the premises or the...
No, that is not, because they said that I am their case before the commercial court, that section 9, I am party to the MOU. Suraksha Selvia filed the case under section 9 before the learned commercial court. There are two entities. Suraksha, if you
They are not a party to the MOU.
They are not the party. They came to be formed. Just see this paragraph, my lord. The facts will be clear. The facts also will be clear, my lord. Kindly see because that has been explained here, my lord. The petitioner and miscellaneous application have been instituted by one entity in the name of Suraksha Selvia LLP. It is submitted that Suraksha Selvia LLP is not a party to the MOU dated 26 and the arbitration agreement contained. In this regard, reference may also be initial description of parties at page 54, Annex 3, which had Suraksha Selvia Global LLP. Your Lordship, kindly see, Global LLP is a private partner. The seal at the bottom of the page also indicates Suraksha Selvia Global LLP. Similarly, clause 1 of the MOU, which describes the parties to MOU, does not refer the name of petitioner herein as a party to them. The agreement nowhere indicates the name of petitioner Suraksha Selvia LLP as a party to MOU. Signature at the end of the MOU also does not carry signature. Clause 9.
You have raised many
contentious issues. Many contentious issues. The court should, and these are the preliminary objections as to the maintainability. And your Lordship, recent judgment of the Honorable Supreme Court is there. When the preliminary objection is raised,
so maintainability has to be taken up
before granting interim relief, my lord. And here interim relief is, your Lordship will kindly see the judgment, recent judgment of this aspect 2024 SSC 696.
Asma.
Yes.
Your Lordship will see paragraph 52, my lord.
Yes.
And paragraph 58, my lord.
The 58.
Yes, my lord.
Yes.
So,
Paragraph 58. My lord, if I read this, if I'm not taking your Lordship's time, I can.
No, you can take the whole day. There is no problem.
No, I
You are educating the court. Just
I'm sorry.
you may face many elementary questions,
No,
but
no.
then
No, I'm grateful, my lord.
enlightening the court. Yes.
I'm grateful, my lord. I'm grateful for the ASMA's judgment, my lord,
Yes.
is a judgment on the proposition, my lord, that if your Lordship will see paragraph 48 onward,
Yes.
we are assisting the courts in the matters. Our duty as a counsel also is to assist. Also, what your Lordship has been saying. Also, in regard to Rafiq Bibi, makes it clear that lack of jurisdiction must be patent on the face of decree to enable by an executing court to conclude decree was nullity. Hence, it is clear that all irregular or wrong decrees would be necessarily be void. An erroneous or illegal decision which would not be void could not be subjected in execution of incidental. Dictum was also affirmed by 3 honorable judges so and so. What follows from a conspectus of all aforesaid decision is that jurisdiction is entitlement of civil court to embark upon an inquiry as to whether cause has been brought before it by the plaintiff in matter prescribed by law, and also whether good case for grant of claim has been set up by. As and when such entitlement is established, any subsequent error till the delivery of judgment could be regarded an error within the jurisdiction. The inquiry as to whether civil court is entitled to entertain or try this suit has to be made keeping in mind the provision of section 9 of CPC and relevant intent, which including the object bar so and so. Although not directly arising in the present case, we also wish to observe that question of jurisdiction would assume importance even at the stage a court consider the question of grant of interim relief, wherein interim relief is claimed in a suit before the civil court and party to be affected by grant of such relief or any other party to the suit raises a point of maintainability thereof, and that is barred by law, and also contains that on the basis of interim relief should not be granted, grant of relief in whatever form, if at all, ought to be proceeded by the formation and recording of at least prima facie satisfaction that suit is maintainable or that it is not barred by law. Such a satisfaction resting on appreciation of averment in the plain, the application for interim relief and the written objection thereto, as well as the relevant law that is cited in support of the objection, would be part of the court's reasoning of a prima facie case having been set up for interim relief, that balance of convenience is in favor of grant and non-grant would cause irreparable harm and prejudice. It would be inappropriate for a court to abstain from recording its inappropriate for court prima facie satisfaction the question of maintainability, yet proceed to grant protection pro tem on the assumption that question of maintainability has to be decided previously. So the sum and substance is, before granting interim relief, you have to record prima facie satisfaction that it is not barred by law.
The plea special is with regard to the jurisdiction of the court.
Yes, my lord. Sine qua non is that you have to record prima facie. Now, kindly come back to the issue, my lord. Kindly come back to the order, my lord. I was placing page 174.
When this matter is coming up before the court
for judgment.
No, my lord, I don't know whether it will be for judgment.
No, why you are?
No, because my concern.
Of course, you see,
I'm
for the court. At least court is,
I understand.
getting enlightened on many aspects.
Yes, my lord.
But then
I understand what is
falling from. Totally futile exercise.
No, I understand. I understand that whether the entire will be required to go and adjudicate the entire matter. If the final judgment is rendered, then possibly my petition become infructuous, because the final all interim orders will get merged with the final order. That is the plain and simple the legal position. What I was suggesting, my lord, because my only concern is.
Anyway, if you want to say some more points, it's okay. This court is getting.
Yes, my lord.
Just,
so
just before we come and conclude,
yes, your lordship, kindly see.
Enlighten us more something.
Yes, my lord. So then, your lordship, kindly see the. Kindly see the order at page 170.
Just one query.
Yes, ma'am.
Like under the Commercial Code Act.
Yes, ma'am.
there is no provision for relief if any interim or ex parte interim order.
I'm grateful, my lord. Now, in Commercial Court Act, we have two acts before in the commercial matter. One under the Commercial Court Act and one Arbitration and Conciliation Act, my lord. So then the Supreme Court has settled the law so far as the Arbitration and Conciliation Act is concerned. The proceedings will take place under the Commercial Court Act, but the relief and appeal, everything will be controlled by the
Arbitration
Act. So both acts are operating.
So that the restriction of Section 8,
yes, my lord,
Commercial Act would not apply here.
No, because the restriction to the extent that, if your lordship will see 37.
See, otherwise, normally,
yes, my lord.
The basic understanding is that
yes, my lord,
the scope of revision has been curtailed by Section 8 of the Commercial Act.
Yes, yes.
But then the law is very clear; it would not definitely not curtail the constitutional power of the High Court.
227. That is why we.
But then 227 is not to be resorted as a regular course.
Yes, my lord.
It should not be something to bypass Section 8.
Absolutely correct.
It is only in exceptional situations.
Yes, my lord. So the parameters
now,
which. I'm sorry.
Kindly, just get the reaction of the court, then you can explain it better. Now, this court understanding is that this, if you take into context the Section 34 and Section 37 of the Arbitration Act.
Correct.
Now, Section 37 basically limits the scope of appeal, isn't it?
Yes, ma'am.
Now, that is where, say, supposing if by application of Section 37,
yes,
if your scope of relief is curtailed and if you depart from taking some points in an appellate jurisdiction, definitely you come and approach under 227.
Yes,
raise this thing.
Yes, ma'am.
Now, the grounds which you are taking here,
yes, ma'am,
if you can raise it before the appellate forum, then there is no reason for this court to.
Yes, go into those grounds. Yes. I bow down. Your lordship is absolutely right. I can raise all these grounds in appeal and in 30. If your lordship will see Section 37, appealable orders of the Arbitration Act.
Of the Arbitration Act.
Yes, my lord. Because appeal is provided under Section 37 of Arbitration Act, my lord.
These are all new subjects for this court.
Every subject. Because your lordship has some time, so I thought that
definitely
in this issue.
Yes.
If an appeal shall 37 says,
yes,
an appeal shall lie, because this is the pertinent query posed by your lordship, and an appeal shall lie from the following orders and from no others to the court authorized by law to hear the appeals from original decree of the court passing order, namely, refusing to refer the parties to arbitration under Section 9, we are concerned with, setting aside or refusing to set aside, B, granting or refusing to grant any measures under Section 9. So the order, this Section 9 has been interpreted when finally decided, I will argue entire matter in appeal under Section 37. That is I will place that authorities and judgment on that. If then I have a right to file an appeal under Section 37. Here, if the commercial court today, my lord, decides the Section 9 finally today, then I have only remedy left that I should file appeal under Section 37. I can't come in 227, my lord. There is absolute bar. That bar is there, my lord. So the legal position is, as on today, against interlocutory orders, I have no remedy. Interlocutory orders passed.
But then, see, it will be a futile exercise.
Yes, that I quite see. What your lordship is right. Only why I am here, because I knew that, and I didn't know that the order is also fixed for final order. Only when the order was uploaded yesterday, my friend informed in the morning that 12th there is the order, because I have placed that also till we don't have the details that it was, if your lordship will see that it is kept for final order, that also is not there. But kindly see the order of the learned commercial court, my lord. Page 174.
Yes.
third paragraph, the learned counsel for the respondent and petitioner both submits that learned the counsel for the respondent has touched upon the maintainability of application section 9 of Arbitration and Consent Act, which shall have direct bearing on commercial. Because we questioned the maintainability, and it is not maintainable both on the ground that party is not party is not signatory to MOU plus barred under the law. Those both maintainability was raised, my lord. So then,
now, if that order, say supposing,
yes, my lord,
without disposing the entire matter, the court passes some order on the maintainability, and that goes against you.
Yes.
Your remedy will be again under.
No, not because if it goes against, then I will come under 227. Sorry. So finally, if it is not finally decided, then I have remedy under 227 because we will say that it is wholly without jurisdiction. It is. Then I will say that the exercise of jurisdiction under a section is barred by law. It is wholly without jurisdiction. Then I have remedy to come before your lordship under 227 only. I have no other remedy, my lord. Your lordship is right. Is that 227 only. Then if your lordship will kindly see 176. My friend has been praying time and again, my lord, that the extension should be granted till the disposal of the case, my lord. That has been opposed consistently by us, my lord.
No, you have taken a plea of maintainability, and that is clear from there.
And your lordship, new ground, then your lordship will kindly see, may be allowed for gist of arguments. Matter was ultimately on 4th, parties were given time to file gist of the argument. 7th, gist of the argument was filed at page 180, my lord. Everything was done and dusted, my lord, on 7th. Thereafter, again for filing of 12th March, it was fixed for 12th March. 12th March, I don't have the order now. Later on, the order came, my lord. So this is the position, my lord. What has happened in the meantime, my lord? Because there was no stay after maintainability, I raised that issue of maintainability. The commercial court, in fact, what has transpired also is that when it was raised, the learned counsel for the petitioner said that if the court is inclined to dismiss, please dismiss the petition on the ground that the party to MOU has not approached the court. This was the oral deliberations, which I cannot take note of that, and I cannot. But these
are two different identities. The respondent hearing and the
is a separate legal, separate juristic entity.
Of course, there appears to be some difference.
I'll explain that.
So that is what I wanted to show at page 200. What is the entity difference, my lord? Kindly see page 200, my lord.
But then is it required at this stage?
No, it is not required, my lord. That is why I am not going into that. So the point now, kindly see, there was no stay operating. The premises are in my possession. I am in control, my lord. One argument will be, no, you are not in control. They will say petitioner was.
You are in constructive position.
I was in constructive, like it's a hotel room, my lord. In hotel room, I gave it to him for using the room, and he will not pay the rent or anything. I can take the position. That the court says, and then your lordship will see the reasoning which has weighed. That is also troubling, my lord. Kindly see whether this kind of reasoning can be given by the court is under impression. Kindly see the application is moved by my friend. Whether it is not improper exercise of power, my lord, is a question which I have put to myself. My friend has filed application at page 212, my lord.
Yes.
The wide order dated, paragraph 2, my lord, 28th February, the Honorable Court had directed no coercive step should be taken till Monday. During the hearing, the counsel had made a categorical statement, no statement whatsoever, my lord, that no steps should be taken against petitioner while the matter was pending consideration of the Honorable Court.
The court has made a statement.
During the hearing, counsel for the state had made, your lordship will see paragraph, to every order I have objected to, and my friend has been praying, give till disposal, my lord. And this
will go as incorrect statement.
This will go incorrect statement. Your lordship is right. So then this is not a statement. Then your lordship will kindly see the order passed by the learned district judge, my lord, commercial court. The learned district and his prayer, my lord, is what? Sorry, I didn't point out that his prayer is, my lord, the prayer of the petitioner before the court at page 200 is, my lord, copy of the, application is at 213. is that, my lord, of the application 212. I'm sorry, my lord, 212, my lord, and 1212. And his prayer is, my lord, that at the police force has arrived, so and so. Then his prayer is to extend. Where is that prayer? Okay, yes, sir. Your this is to revive the interim order. What, so his prayer is that was no interim order. As on today, when I took the position, please revive the interim order.
That is what revival means. What something expired, you want to?
You want, yes, something expired. If something expired and there is no order, the court has to consider whether he is entitled to relief of revival or not.
Anyway, see, like this, all those questions.
Yes, my lord, I understand that at the end of the day, and your lordship, I have one more issue, one short issue, my lord. Kindly see the impugn order at page 225. The order starts from page 222, but
yes,
the court was under the impression that OP would not take any coercive till the matter is decided, my lord. Whether I put a question to myself, my lord, whether on the basis of impression.
Now, what is the basis of this impression?
Impression also.
In fact, the order says that you are opposed.
Opposed, and then, your lordship, I just wanted to place a recent judgment of the Honorable Supreme Court on oral orders and aspects. Because my lord, what has been, because his case is revive the order, stay order. My friend's case is that application is revive the stay order. The learned district judge says, my lord, that no, you have taken the position illegally and finally decided the recovery of position suit and hand over the key, etc. Whether under section 9 this order could have been passed. The recovery suit, my lord, with the recovery, etc., my lord, just for the sake of.
At the best, if court found that you have violated any order,
I should have been penalized. I should have been penalized. Proceeded with this. And your lordship, kindly see the
could not have revived, or they could have.
Revive.
This, what about that?
And your lordship,
violation of injunction. There is provision in.
Yes. And your lordship, kindly see paragraph, because 28 of this judgment, my lord.
Yes.
Because in other cases also some oral orders, etc., keeps coming, my lord. Paragraph 28. 28.
Yes. This is a criminal procedure.
A criminal proceeding, my lord, but the principles by and large are applicable. It has been dealt in civil matters also. Paragraph 28. Oral directions by this court, by this nature of the High Court, are liable to cause serious misgiving. Such a procedure is open to grave abuse. Most High Court deal with voluminous cases. Judicial assessment change with the roster. Absent of written record of what has been transpired in the course of judicial, it would be set a dangerous precedent if the parties and investigating are expected to rely on unrecorded or oral observation. And then 28, my lord, last 3 lines. The element of judicial accountability is lost when oral regime prevails, my lord. This will apply to, this would set a dangerous precedent and is unacceptable. Judge as a public official over whose conduct they preside are accountable for their actions, my lord. So what my submission is that you cannot go by impression, my lord. In the impression is anathema to rule of law, is anathema to.
There cannot be two different views on.
Yes, my lord. That's a settled principle of law, my lord. This is and my lord, if I just place those authorities, which compilation which we place before the court also, where this issue under section 9, whether you can grant those kind of relief barred by law or not.
You can pass it on us,
yes,
but then this court will not decide.
I understand.
Mr. Shen perhaps is getting impatient.
So what I suggest, if subject to what my friend says, my lord, because the issue is that a status quo to be maintained, because my difficulty is, my lord, my friend, if gets compensation, I have no issue. Whatever loss has been caused to him, we are ready to pay, or we are ready to settle also. That is not an issue. My difficulty is, my lord, that my medical, we have applied for 50 seats, my lord. Right or wrong, we have taken position, my lord. 50 seats in December. And the pasture institute will be used for the academic law. Inspection can be carried out by the NMC at any point of time. If they carry out inspection, it is logged and handed over, then we will not get the
But
back.
then if you do something without
Yes, now the question,
finally selecting a premises, then
no,
who would be
that is,
responsible?
if I do something against law, I am bound to restore it, and I am bound to.
Initially, you said that MOU was of 2019.
Yes, my lord. It
and
was for 10 years.
Your project of medical college came up in 2020.
Yes, my lord. If
that was your intention that you will establish a medical college in
Yes,
the
my lord.
premises which you allotted to them, in such a situation, you should have made some arrangement to get it vacated.
I have done that. That proceeding also is there. No, I have also, if lordship is kind enough, if I, on merit of the aspects also, if I have to satisfy your lordship, kindly see this aspect also. We went to them, and this under the MOU, it was only land to be allotted on which they would have built the infrastructure. There was no provision in the MOU that I'll give pasture institute. Your lordship is aware. Sometimes.
But then once you allow them to start functioning,
Yes, my lord. And
thereafter, without allotting them a separate land,
they are functioning in collusion with my officials, my lord, and then they are in, and that is there. That is why I know. It's a matter of fact. But only thing what I was saying, my lord, status quo to be maintained.
Perhaps
Status quo to be maintained, because I will lose. I would not have come here trouble your lordship against the interim order.
But in this, status quo. See, it is only question if the order comes today, even
Then I have
order
to
pass will not have any.
Yeah, my only thing is that, my lord, I am before your lordship, and then because there is a direction which is on the face of it is that I should hand over the keys and possession, etc. That is a direction which is troubling us. Otherwise, I would not have, and that too based on impression, my lord. That is based on impression. So, if the final order is passed, your lordship may not be required to go and adjudicate all these issues. But if there is no final order,
if you want this court to adjudicate it, this is also at this order will not be. This court will not be able to complete the order. That's for sure. Touching all those things. But then the thing is that there is no question of getting the matter disposed on the very first day of the motion.
Yes, my lord.
Yes.
So
that petition, what about the prayer for status quo?
Lord, may I just address the entire
Why
issue?
not? Yes, please.
First, I'll start with.
So, if my friends is going into the entire issue, only few judgments on this section 9, my lord, which I placed, my lord. The first judgment, my lord, is.
This is not there in your compilation.
Yeah, this is in compilation, my lord. If you lord separate compilation. Yes, lordship, the thick
Those
volume.
other judgments which you have given, this
Yes,
is not
yes.
a part of your compilation.
It's not part on the on not section 9, my lord, on the different aspects of the section.
Now, if you want this court to go through all these judgments,
I'll put it in one. I will put it in one index, my lord.
This will be humanly impossible for this.
I will put it in one index, my lord. I'll put it in one index, my lord. First judgment is, my lord, of Delhi High Court, which deals with lengthy judgment, but I will only point out the relevant one, my lord.
Yes.
Is one, and then your lordship will kindly see paragraph. It is a case of, my lord, the determinable agreement, my lord.
Yes.
And paragraph 18, my lord.
That page.
To 18 at page 26, my lord.
Page 26 or page 6?
Sorry, your lordship, this is the compilation.
This is compilation which I am holding?
Yes, your lordship. Kindly see page 26.
Okay, 26. Yes.
Learned counsel for the petitioner contended that a careful reading of clause 23 point of contractual agreement established that it was one of the nature of determinable. The submission essentially was of clause 23.1 enables NHIDCL to terminate the contract only upon occurrence of eventualities enumerated therein or based on assertion breaches of contract or default on the part of contractor. It was submitted that the act of termination was thus dependent upon breach of default as distinguished from a power that may have been vested in NHICL to determine the contract for any reason whatsoever or for the matter without assigning any reason at all. So the sum and substance in paragraph 18 is a termination only on happening of certain event. Without that, there can be no termination, my lord. That was the argument submitted. And then your lordship will see paragraph Then Indian Oil Corporation judgment is quoted, my lord, because this is the judgment, page 28, your lordship will, this is the judgment holding the feed on determination of the contract, page 28, my lord. The Supreme Court judgment, which is referred at page 28, my lord, paragraph,
Yes.
section 14 of SRA as appearing in the decision of Supreme Court in Indian Oil Corporation versus Amritsar Gas Service, Mr. Tandon referred to following passage. Arbitrator recorded finding on the issue of now that termination of distribution agreement by the was not validly met. Thereafter, he proceeded to record on finding so and so, so and so. Your lordship will kindly come to the underlined portion of the judgment at the foot of the page of the Indian Oil. The finding read along with reason given in the award clearly accept that distribution could be terminated in accordance with terms of the agreement dated which contains the aforesaid clause. Having said so in the award, it is obvious that arbitrator held the distribution to be revocable in accordance with clause 27 and 28 of the agreement. It is in this sense that award describes the distribution agreement as one of the indefinite period. It is till terminated in accordance with section 28 or 25 of the award. Now, my lord, kindly see the last 5 lines. Subsection 1 of section 14 of specific act specifies the contract which can be specifically informed and which is on one of which is a contract which is in nature which cannot be specifically enforced, one of which is a contract which is in its nature determinable. In the present, it is not necessary to refer to other clauses of subsection 14.1, which also may be attracted in the present case under clause C, clearly applies to the finding reading reason given by itself. That being so, granting relief or restoration of distribution even on the finding that breach was committed by the appellant corporation is contrary to mandate of 14.1 of the Specific Relief Act. There is an error of law apparent on the face of award, which is stated to made according to law governing such cases. Grant of this relief cannot be sustained. So, some instances, if it is an error on my part also, the section law bars, he will be entitled to compensation, damages. Because he cannot get the relief of this, my lord. And then paragraph 30, my lord, at page 44. Having noticed the submission addressed, this court notes that section 14 of SRA specifies contract which are not specifically enforceable. Clause D of 14 stipulates that contract which is in its nature determinable cannot specifically be enforced. Regeneratively, grant of an injunction in respect of such contract stands prohibited in the light of 14.1e of SRA, which prescribes that injunction cannot be granted to prevent breach of a contract, the performance of which would not be specifically enforced. The first issue was therefore arises is whether the contract agreement in the present case one fall within the parameters of 14d of SRA, my lord. And after examining all these issues, my lord, I am not going into the fact. Kindly come to page 63, paragraph 46. Page 63, paragraph 46 and 47. This court also bears in mind that even though it is a constitutional court, while trying the instant petition, it is essentially called upon to consider the exercise of power conferred under the special statute. It would thus perhaps be impermissible to invoke its constitutional power of judicial review while considering a petition under section 9 of the Act. The adoption of such a course would also run afoul, ultimately, since even if it were eventually come to the conclusion that action is arbitrary, its power to grant injunction would still be dependent upon subject of provisions of 14d of SRA. 47. The invocation of judicial review power in proceedings under section 9 would also fall which will be enumerated in Rajasthan Bureaus and so and Overnight Express and Indian Railway Corporation, all of which had consistently held that merits of determination of contract are issues which must essentially left for determination by arbitral tribunal. Position has been reiterated in recent decision of learned judge in the so and so. So the whether my termination is bad, good, ugly, that has to be examined by the arbitral tribunal, and whether the actions taken under that is the scope of section 9 is, my lord, at page 64, your lordship has seen 48. So all these issues, my lord, are subject matter of examination by, and then your lordship will kindly see the next judgment of Delhi High Court at page 78. Because all these judgments are arising in section 9, my lord. Paragraph 12 at page 80, my lord. Paragraph 12, the 11th, my lord, sorry. I have carefully gone through the relevant documents, including contract, etc., my lord. Then paragraph 12. The term determinable in nature has not been defined under the any statute act. Would the word determinable in legal parlance shall indicate and suggest liable to end upon happening of contingency. Thus, any contract which provides for termination at the instance of either of the parties or of occurrence of non-occurrence of certain events is determinable in nature. It cannot be said that only contract which was terminable without any cause would be called determinable in nature. I may also, however, hasten to add that agreement executed for indefinite duration, such as partnership, employment, public leases, and perpetual lease, generally contain no termination clause. However, still in absence of thereof, in a given case, such indefinite or indefinitum contract without termination can also be declared inherently determinable while applying the rule of reasonable. Be as it may, the import and scope of determinability of any agreement needs to be understood and gathered after analysis of contractual term and bought. So there the case is that even the terms which say that not determinable can also be determined, my lord. This, and then your lordship will see the next judgment at page 93 at relevant paragraph is at page is 95. Similar argument was placed before the learned single judge, paragraph 9, paragraph 8, my lord, at page 95. He places reliance on 14D of specific relief act and to submit that contract being determinable in nature, same cannot be specifically enforced. Placing reliance 9 on 20A and 41HA of the specific relief act, he submit the injunction cannot be granted against the termination of contract as contract in question relates to infrastructure project. An order of injunction would cause impediment or delay in the progress of completion of such infrastructure project. Land Council respondent submit the record would reveal so and so, my lord. And then the learned single judge, my lord, at paragraph 12 and 13 refers to the relevant provisions of the specific relief act and comes to paragraph 14, my lord, paragraph 14 and 15. A reading of the above provisions would show that injunction involving contract relating to an infrastructure project specified in the schedule to a specific relief cannot be granted, as it may cause impediment or delay in progress or completion of such infrastructure. Serial 1 of the Schedule Act, Roads and Bridges. The contract in question clearly falls within the above entry. Therefore, an order of injunction should not be granted, as it would prevent the respondent authority from getting the work completed expeditiously. Even otherwise, the respondent has alleged that petitioner, even for the land was made available, was not carrying out the work with expedition. Though this is denied by learned senior counsel for the petitioner, it will be a matter of dispute adjudicated by learned arbitrator. For prima facie opinion, even recommendation of authority engineer that both the petitioners are responsible for delay in project. Authority engineer has recommended for a date of completion of milestone. Petitioner has taken a plea that has scattered stretches so and so. In view of the, I find that the petitioner has not made out a case for grant of injunction against the termination of notice. Question of invocation by guarantee, etc. We are not concerned, my lord. The next judgment, my lord, is paragraph 98. Page 98, paragraph 19 at page 102, my lord. Paragraph 19 at page 102, my lord. Law on the scope of interference in a section 9 petition is no longer res intriga. Learned single judge held that prayer made by the appellant in the section 9 cannot be granted, as it would amount to extending the contract contrary to decision of so and so. It is well settled that power under section 9 can only be exercised for preservation of the subject matter of the dispute till the decision of arbitral tribunal and cannot be extended directing a specific performance of contract itself. Learned single judge in the context relied on judgment of division bench and our view rightly so, reliance has also built the judgment of another division bench in so and so. We find no infirmity in prima facie view that directing respondent to extend the we find that directing to the extend contract for 14 months would amount to granting a specific relief of contract which is beyond the scope of powers of the court under section 9. For ready reference, all these judgments are cited, my lord. Then the Supreme Court also, my lord, at page 104 in Cox and King, at similar view has been taken at 111, my lord. Everything has been left to the arbitral tribunal, my lord, because my friend's claim is that he is entitled to either specific performance of the contract or he has to be compensated for illegal or breach of the contract. These are the only two reliefs my friend can seek in the remedy. Now, so far as specific performance of the contract, my lord, the law is consistent, law is there, even Amritsar Gas, that there can be no specific performance, but he will be entitled to compensation if he proves that my termination is wrong, and that point will be examined by arbitral tribunal. He is not remediless, he is not without remedy, but when there is an exercise of power by the court below before and I have no remedy under 227, because just now my colleague has sent the view taken by on this issue whether appeal will lie or not. This judgment your lordship may have that just now, because that this is a question which fell whether these issues can be examined in appeal or not under section A, the Relief Act or not. In that case, my lord, if your lordship will see,
yes,
appeal was preferred against the interim order, my lord, in paragraph 2.
This is by our High Court.
Our High Court, my lord. Because I have been doing all commercial matters only through paragraph 2. The present appeal has been preferred by appellant under section 37 1B of Arbitration and Conciliation Act as amended, read with section 13(1) of Commercial Court Act against the order of dated passed by judge so and so in commercial. Impugn order came to be passed on application of 39 filed by the vacation of ex parte ad interim on application of section 9. Arbitral tribunal which was filed by way of interim order, learners directed for maintenance of status quo regarding encashment of letter credit and has been opened in favor of the appellant. So interim order was passed pending section 9 application, my lord. Against that appeal was preferred, my lord, under 37, my lord, and then this appeal, my lord, was rejected by saying that after examining exhaustive judgments of the Honorable Supreme Court, my lord, examining the provisions, my lord, if your lordship will kindly see those provisions at paragraph 29,
Yes.
Commercial Court Acts, my lord, was examined, Electricity Act was examined, my lord, then Arbitration Conciliation Act 9 section 9 was examined, my lord, and then paragraph 31.
Yes.
Section 37 1B contemplates appeal against the final orders only and not against ad interim order, and this stipulation is underlined by the fact that word ad and from no others has been used in said provision. Read with section 8 of Commercial Court Act. The scope of appeal is further narrowed down in as much as these provisions bars any petition against any an interlocutory order of the Commercial Court, including an order of issue of jurisdiction. Further, it is stipulated, including an order and issue of jurisdiction. Further, it is stipulated any such challenge will be subject to provisions of section 13 shall be raised only in appeal against the decree of the commercial. Coming to section 13 of Commercial Court Act, this provision clearly confers does not confer an independent right of appeal, and the proviso to section 13(1)(a) has circumscribed the types of appeal can be preferred by making subject to order 43 and 37 of arbitration. What emerges therefore is that instant appeal has to satisfy the test of section 30, which observed here provides for limited right of appeal against mentioned 37(1), my lord. And then ultimately your lordship's final view has been taken that appeal is not maintainable at paragraph 41 against the interim order. So my difficulty, my lord, is that against interim order there is no remedy of appeal, and the only remedy of appeal is, my lord, that I have shown that 1997 judgment, my lord, that's Achyutanand Badya judgment, my lord. Kindly see paragraph 10 once again. That is 1997 5 ACC. Paragraph 10, my lord. The power of superintendence of High Court under 227 of the Constitution is not confined to administrative superintendent only, but such power includes within its sweep and power judicial review. The power and duty of the High Court under 2 is essentially to ensure that courts and tribunals inferior to High Court have done what they were required to do. Law is well settled by various decisions of this court that High Court can interfere under 227 of the Constitution in cases of erroneous assumption, arbitral tribunal power exercised by the commercial court, or acting beyond its jurisdiction, refusal to exercise jurisdiction, error of law, apparent, my lord, I say in view of SRA, Specific Relief Act, and also allowing the application for revival, and revival is being converted into suit for possession under section 9, my lord. These are the assumptions which the court below could not have exercised under the law, my lord. So I have no remedy of appeal under 37, my lord. The assumption is wrong, my lord. Then I have only remedy left. I can't be rendered remediless against the illegal order passed, my lord. Your lordship has always held that parties cannot be left remediless, and the state is a party before your lordship. The state cannot be rendered remediless in view of the assumption of power, in view of the illegality in the passing of the order, my lord. And then I have, your lordship, I have shown, my lord, that at no stage my friend has all along been praying that please extend the stay throughout. When I argued the maintainability, when I argued thereafter, the stay was not extended, my lord, and it has to be by speaking order. So therefore I have taken the position, my lord, position that if position is wrong, my friend can file a separate case position to get the decree of position saying that my position is against the contract, but I can show the provisions of the contract. Under that I am entitled to take position, but that issue will not be required to be gone into under section 9 or 227. It has to be gone into by the arbitral tribunal. I am grateful for giving patient
opportunity for the court to hear you.
My lord.
Yes.
It please your lordship.
Yes, yes.
So the first issue that I will raise again is the maintainability of this petition itself. So this is an application under Article 227 challenging a particular order directing restoration of possession. Not even restoration of possession. Please just have that order for a moment, my lord. This is an order dated 19/3/25 at page 222.
What is a prayer? Before that thing, what is a prayer made in this?
To set aside that particular order. Please see, the prayer is at page 20.
Yes.
Lordship, in the premises aforesaid, it is prayed that your lordships may be pleased to call for the records and issue a rule calling upon the respondent to show cause as to why a writ in the nature of certiorari or any other writ shall not be issued, quashing and setting aside the order dated 19/3/25 passed in commercial miscase number 1 and so, bearing so and so.
That is the only order challenge.
That is the only order. Yes. Now, please see, my lord, and I'll come to the NTPC judgment. It's a very interesting judgment. It helps me in my case. So, after the application was filed, the court passed one particular order granting some sort of interim relief. That is at page 156.
Yes.
So the first order that was passed was an ad interim ex parte order at page 156, order dated 12/2/25.
Yes.
So my lords have it. This is the order dated 12/2/25.
Yes.
It's a lengthy order.
Yes.
The operative part of the order is at page 170.
Yes.
Right. So kindly see the second last paragraph at the bottom. The court is therefore of the considered view that the petitioner has a prima facie case in their favor. She goes on to record that all three requirements necessary for grant of an injunction are present in this case. This is the subjective satisfaction of the court. And my lords, can you see the order which is passed? Therefore, this court at page 140, at page 171, the third last paragraph, yes, which is highlighted in bold. Therefore, this court hereby grants ad interim, interim ad interim injunction till next date, restraining the respondents from giving effect to the NIT notice of termination dated 31/25 and are restrained from disturbing the possession of the petitioner at the subject so and so property dated 31/25. So there are two orders which are passed in terms of my prayer. One relates to the suspension or the termination of the notice of termination, and number two with regard to my possession of the subject with the property. Thereafter the enter appearance, and can you see the next order at page 174, which my learned senior had read out. This is the order dated 25/25. So in very quick succession, orders are passed, and in this order, Lordships will see they raised a question touching upon the maintainability of my application, and they made a prayer that they had an objection with regard to the extension of the stay order. Even on this day, and I understand that this was not recorded, a categorical undertaking was made by the council that there is no need to pass any interim orders because the state will not act in this matter. I understand, and I'll just come to it. I'll come to it, Lordships. I'll satisfy Lordships. So what the court does is, kindly see at page 175, the second last paragraph. It says, in the interest of justice, the petitioner shall not take any coercive steps till Thursday. Now please see, this is repeated for another date or two. These are the interim orders that are passed, as is referred to in the NTPC judgment. None of these orders were ever challenged on the ground of maintainability, jurisdiction and so on. No 227 application was ever filed against any of these judgments. Please take note of that. So this goes on, even your Lordship will find in the next page at page 176.
These two orders were not challenged.
No, none of the orders thereafter also, all the successive orders.
Before
where
any other authority.
Yes, the extension where the court directs that no coercive steps should be taken, this goes on for some time, but none of these orders are challenged. Not even the first ex parte order. None of these are challenged. Thereafter, again, I know this is a difficult proposition for me because this was not recorded by the learned court. The council for the state makes a statement that there is no need to pass any orders. We are not going to take any action in the matter. Judgment is reserved. Hearing is concluded. And then, please see what happens thereafter at page 221. So on the 18th of March, we are visited by the state administration. There is a show of force. Magistrates, police personnel, so on. They visit this particular property and they forcibly throw me out. So I file an application for some sort of interim relief in the morning itself, when this process had not even started. So by the time it ended, the order came out in the evening, so court had to mold the relief. But please see the order dated 18th March 25. This is some internal communication between the department, and on the basis of this order, apparently, this exercise was conducted. Yes. Your Lordships have it, page 221.
Yes.
So this has been issued by the Commissioner and Secretary to the Government of Meghalaya Health and Family Welfare Department. And it is issued to the DC of East Khasi Hills. The subject is taking possession of Health and Family Welfare Department buildings currently occupied by so and so. Madam, in reference to the legal opinion of the learned AG, Government of Meghalaya dated 18th March 25, in connection with case number so and so in commercial arbitration so and so at the Honorable Commercial Court in Shillong, as attached in Annexure 1, you are requested to immediately detail an executive magistrate accompanied by the police personnel to take possession of the Health and Family Welfare building in Pasture Institute, currently under the possession of Suraksha Salvia Global LLP. Please also take note of the name. I don't think this is relevant, but my learned senior was making some distinction with the name of the firm. Again, the name of the firm indicated here is Suraksha Salvia Global LLP, and according to them, this firm does not exist. And it goes on to say, in the presence of the representatives of the Director of Health Services, MI. Furthermore, videography documentation of the entire proceeding shall be done with date and time stamps. So pursuant to this, they take over the property, and please see, this event happens on the 19th of March. So we are now equated, citizens are now equated with hotel occupants, and the rule of law is suspended for some reason. Constitution is abrogated temporarily, and then finally they come and forcibly take over with a complete show of force. So this is a notification dated 19th March 2025.
What is the termination notice? Where is the termination notice? Termination
notice. May I just read this for a moment? I'll take your Lordship to the termination notice. So this reads, subject notification of building takeover. In accordance with the notification dated 18th March 25, it is hereby notified that the buildings previously occupied, now kindly see the name again, Suraksha Salvia LLP. This is the petitioner before the trial court. They say that this petitioner has no locus, and that is the core submission on the maintainability of the case. They say that Suraksha Salvia LLP is not a party to the proceedings. But yet again in this letter, and I'll show your lordship several correspondences where they've referred to this particular entity as a party. So it goes on to say, previously occupied by Suraksha Salvia LLP have been officially taken over by Health and Family Welfare Department on 19th March 2025 at 11 a.m.
You are reading which page?
But at page 220, okay. In Annexure A.
Oh, yes.
May I just read that again? Subject is notification of building takeover.
Yes. All right, sir.
And it says the takeover process was conducted in the presence of the following officials. Then, my lord, we'll see the order. So I filed an application which is at page 212. So on the 19th morning, when I was visited by the state officials, I immediately rushed to court and made an application.
Yes.
212, my lord. Kindly see para 2 of my application.
Yes.
That by order dated 28 to 25, this honorable court had directed that no coercive steps should be taken till Monday. During the hearing, the counsel for the state had made a categorical statement that no steps would be taken against the petitioner while the matter was pending consideration of this honorable court. At that point, the court orally remarks and informs the junior counsel for the state that please inform the department to open the locks. This is not acceptable. The order is not ready because the court is busy with other work. By the time the court is actually ready, we had to report back to the court and we say that this taking over process is going on, or they put a lock. So the court modified its order. But before that, they come back with a note of objection, which is at page 215. So despite the oral direction of the court, they do not comply with it. Within a couple of hours, they come back with this particular note. If your lordships have it.
Yes.
I have gone through this entire note. They raise in the... No, I'll point out something very interesting.
No, we can go through, but then...
No, I'll point out just something very interesting. I know the lordship's concern is if the state has made an undertaking, it is not reflected in the order. That is correct. I have made a categorical statement in my application on that very day that the state council had given an undertaking before the court. They responded to it with this note. Nowhere have they denied it. Not once. Not once has that been denied anywhere before the court. So if they feel that I have made a false statement before the court, they should have made a categorical denial here. There is no denial on record. Now please see page 222.
What they say in their objection note?
They re-raise the question of
maintainability.
They refer to various judgments and so on.
Most on technical aspect, not
whatever
on
arguments have been extended. Whatever arguments have been extended during the course of the hearing, they summarize that here. That is what is summarized. But they do not deny the fact that they made a categorical undertaking before the court. That is not denied anywhere. And this is very important. Now then, the court passes an order in the evening of that very day, 19/3/2025, which is at page 222. Now I think lordships were given the impression that there is a particular statement here which is apparently wrongly noted by the court. That is incorrect. Kindly see the third paragraph. Court has just noted my statement in my application. Please see the third paragraph. Learned counsel for the petitioner submitted that while order dated 28 to 25, this court had directed that no coercive steps should be taken till Monday. During the hearing, the counsel for the state had made a categorical statement that no steps would be taken against the petitioner while the matter was pending consideration of this court. Court is basically reproducing what I had said in my statement, in my application. This is not what the court is recording. Then, please see the next paragraph, page 223. Because this was very disturbing for the court as well. Because court is aware, in fact, if lordships want, I can file affidavits from all the counsels that were present, that a categorical undertaking was made by the court. Please see the last paragraph at page 223. I have perused the annexures filed by the OP. From documents annexed by OP, it is apparent that petitioner was still in possession of the suit property till this morning. It is also apparent that the OP has proceeded to take possession of the suit premises on the basis of a legal opinion dated 18/3/25 and directed the Deputy Commissioner East Castle Shillong to take possession by the letter number so and so dated 18th March 25. The OP has thus taken possession of the suit premises today, the 19th March 25 at 11 am, with the assistance of the district administration. There is thus no iota of doubt that the disposition has been without following due process of law, as the OP has not placed before this court any proceedings being initiated against the petitioner for their disposition. This was with reference to my submissions that they should have initiated at least PP proceedings against me. Then the court goes on to note, it is a settled position of law that a person in possession cannot be dispossessed except by recourse to law. Dispossession without due process is in violation of legal rights and cannot be condoned by the courts. Individuals in settled possession have a right to remain until legally evicted regardless of their title to their property. Then the court reproduces a paragraph from a particular judgment. Then please see the next paragraph at page 225. Yes. At page 225, the last paragraph. This court was under the impression, this is what the court records. This court was under the impression that the OP would not take any coercive steps till this matter is decided. However, the action of the OP in forcibly dispossessing the petitioner without following the due process of law is uncalled for, especially from the government. Taking a cue from the aforesaid judgment, this court cannot turn a blind eye to the unlawful conduct to dispossess the petitioner from the demised property. If the court gives acceptance to such high-handed action, there will be no respect for rule of law, and unlawful elements would take hold of due process of law for ransom, and it would be a field day for anarchy. Due process of law would be put to ridicule in the estimate of law-abiding citizens, and the rule of law would remain a mortuary. Hence, in view thereof, this court hereby directs that the OP shall remove the lock and restore the suit property to the possession of the petitioner. That a copy of this order be served upon the counsels for the petitioner OP, who shall communicate this order to the parties. This is not an interim order. This is a final order. With regard to my prayer, court has molded the relief, taken note of the abject conduct of the state, and directed that the lock and key should be removed. In my understanding, this is not an interim order. Now let's just come back to the NTPC judgment, and then I'll take your lordships to the question of maintainability. Please have the NTPC judgment that my learned senior referred to. Interestingly, when my learned senior was moving the NTPC matter for the trial court, I was assisting the learned AG in this matter. Please see para 2. There's the first paragraph here, numbered as para 2. The present appeal. So in this case, against whatever order was passed by the learned commercial court, NTPC preferred a statutory appeal under the Commercial Courts Act, under 37(1). So that is recorded here. The present appeal has been preferred by the appellant under section 37(1)(b) of the Arbitration and Conciliation Act 96 as amended, read with section 13(1)(a) of the Commercial Courts Act against the order dated 11/5/21. Just please take note of this order date, my lord. Order dated 11/5/21 passed by the Judge Commercial Court, East Khasi Hills, Shillong, and commercial arbitration case number so and so. The impugned order came to be passed on an application under Order 39 Rule 4 filed by the appellant for vacation of the ex parte ad interim order dated 22/4/21. It is in this background that the court records as an interim order. This is very, very different from the case at hand, and the court goes on to record that the original order which was passed was an ex parte order. Without filing any show cause, the MPDCL filed an application for vacation under Order 39 Rule 4. This is further discussed, my lord. I'll just take your lordship to that. Please have internal page 16, para 33.
Yes.
Your lordships have it, para 33. Yes. The appellants admittedly have neither filed a show cause nor contested the application under section 9 on merits, but have instead filed an application under Order 39 Rule 4 seeking vacation of ad interim order dated 22/4/21 on the ground of suppression of facts and for dismissal of the section 9 application on the question of jurisdiction. Similar situation. Section 37(1)(b) of the Arbitration Act provides that the grant or refusing to grant any measure under Section 9 is appealable. Therefore, in light of the provisions, what first needs to be examined is the nature of the interim order and as to whether it would amount to a final order or a step towards a final interim order under Section 9. Then please see para 39. So there is a clear distinction of facts, and Lordships are aware, even if there is a small change in the facts, it would change the complete outcome. If Lordships have it, para 39. Apart from the application of law to the instant case on the question of maintainability, an aspect which cannot be overlooked is the fact that the interim order dated 22/4/21 passed under Section 9 of the application is not under challenge in this appeal, which in our opinion is the core issue, as these proceedings commenced before the learned commercial court below on the Section 9 application itself. So the court records that the ex parte interim order, which at best can be termed as an interim order, was never challenged before the court. And also what was passed in the Order 39 Rule 4 application is what was challenged. If your Lordships in that light look at the order under challenge, one cannot say it's an interim order.
But then is
Now,
it
my
not,
lord-
say like this order passed under Order 39 Rule 4 merges with the order passed under
No, there 39 Rule 4 was dismissed. There again they filed an appeal, a statutory appeal. Now, my learned senior has also referred to a judgment of Asma Latif. I'll just make a quick distinction in this. 2024 4 SCC 696. This is to say that once a question of maintainability is raised before the court cannot pass any interim orders. Now, there's another important factor, my lords. Even after filing my application, they have till today not filed any show cause. Whatever submissions have been made are oral submissions on the maintainability of the case. If Lordships have it, page 716, para 46.
Yes, please.
This reads, my lord, the essence really is that a court must not only have the jurisdiction in respect of the subject matter of dispute for the purpose of entertaining and trying the claim, but also the jurisdiction to grant relief that is sought for. Once it is conceded that the jurisdiction on both counts is available, it is immaterial if jurisdiction is exercised erroneously. Now, this is important, my lord. An erroneous decision cannot be labeled as having been passed without jurisdiction. It is therefore imperative that the distinction between a decision lacking in inherent jurisdiction and a decision which suffers from an error committed in exercise of jurisdiction is borne in mind. What is being therefore argued before the court today is that the learned trial court did not have any jurisdiction whatsoever in view of the statutory bar contained under the Specific Relief Act. That is very different from saying that the learned trial court
Exactly,
did not
Mr.
have
Shan,
inherent
that is what-
jurisdiction.
That is what the question
Yes,
was,
my
is
lord.
that whether the court lacked inherent jurisdiction.
That is not the case.
It is
That is not the
there.
case at all. My lords will look at their application
But
under
then,
227.
if there is a mere erroneous exercise of jurisdiction,
That is appealable.
then that will not be maintained.
Yes, my lord. Yes, absolutely. So that is a distinction in their own judgment.
That is the thing which was striking mind of this court.
Lordship. And that has been held in the context of other cases as well. Now, please see, I'm referring to a judgment, a very recent judgment, 2022 10 SCC 477, Muhammad Ali versus V. Jaya. So this is on the question of in what situations can the court exercise jurisdiction under 227, especially when there is an appellate provision, whether the provision for an appeal. Please see page 483.
Yes, please.
Para 18 minutes.
Yes.
At this stage, the decision of this court in so and so is required to be referred to. In the said decision, it is observed and held by this court that whenever the proceedings are under the CPC and the forum is the civil court, the availability of a remedy under CPC will deter the High Court, and therefore the High Court will not entertain the revision under 227 of the Constitution of India, especially in a case where a specific remedy of appeal is provided under the CPC itself. Then please see the next page, para 19. Yes. Applying the law laid down by this court in the aforesaid decision to the facts of the case on hand, the High Court ought not to have entertained the revision petition under Article 227 of the Constitution of India against the ex parte judgment and decree passed by the learned trial court in view of a specific remedy of appeal as provided under the CPC. Therefore, the High Court has committed a grave error in entertaining the revision petition under Article 227, challenging the ex parte judgment and decree passed by the learned trial court, and in quashing and setting aside the same in exercise of powers under 227 of the Constitution of India. So again they reiterate, once there is a specific provision for appeal, the question of exercise under 227 does not arise. Then please see the next judgment, 2022 1 SCC, page 75. So now this is in the context of the Arbitration Act. Please have page 82, para 11. Yes, that's page 82, para 11. Having heard both the parties and perusing the material available on record, the question which needs to be answered is whether the arbitral process could be interfered under Article 226, 227 of the Constitution, and under what circumstances. We need to note that the Arbitration Act is a code in itself. This phrase is not merely perfunctory, but has definite legal consequences. One such consequence is spelled out under Section 5 of the Arbitration Act, which reads as under Section 5, extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. The non-obstante clause is provided to uphold the intention of the legislature as provided in the preamble to adopt the unilateral model law and rules to reduce excessive judicial interference, which is not contemplated under the Arbitration Act. And please see para 18. In any case, the hierarchy in our legal framework mandates that a legislative enactment cannot curtail a constitutional right. In Nivedita Sharma versus so-and-so, the court referred to several judgments and held thus. We have considered the respective argument submissions. There cannot be any dispute that the power of the High Court to issue directions, order or writs, including writs in the nature of habeas corpus, certiorari, mandamus, quo warranto, prohibition under Article 226 of the Constitution is a basic feature of the Constitution and cannot be curtailed by parliamentary legislation. L. Chandra Kumar versus Union of India. However, it is one thing to say that in exercise of the powers vested in it under Article 226 of the Constitution, the High Court can entertain a writ petition against any orders passed by or action taken by the state and any other agency, instrumentality or any public authority or order passed by a quasi-judicial body authority. And it is an altogether different thing to say that each and every petition filed under 226 of the Constitution must be entertained by the High Court as a matter of course, ignoring the fact that an aggrieved person has an efficacious alternative remedy. Rather, it is settled law that when a statutory forum is created by law for redressal of grievances, a writ petition could not be entertained ignoring the statutory dispensation. It is therefore prudent for a judge not to exercise discretion to allow judicial interference beyond the procedure established under the enactment. This power needs to be exercised in exceptional rarity, wherein one party is left remediless under the statute or clear bad faith is shown by one of the parties. This high standard set by the court is in terms of the legislative intention to make the arbitration fair and efficient. In this context, we may observe Deep Industries versus so-and-so, wherein interplay of Section 5 of the Arbitration Act and Article 227 of the Constitution was analyzed as under. I'll just skip this part. Please see the next page, para 17. Para 17. The extract from the same judgment. This being the case, there is no doubt whatsoever that if petitions were to be filed under Article 226, 227 of the Constitution against orders passed in appeals under Section 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, we cannot forget that Article 227 is a constitutional provision which remains untouched by the non-obstante clause of Section 5 of the Act. In these circumstances, what is important to note is that though petitions can be filed under 227 against judgments allowing or dismissing first appeals under 37 of the Act, the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy as adumbrated by us herein above, so that interference is restricted to orders that are passed which are patently lacking in inherent jurisdiction. Again, they make a very clear distinction. Then it goes on. In the instant case, respondent number 1 has not been able to show exceptional circumstance or bad faith on the part of the appellant to invoke remedy under Article 227 of the Constitution. No doubt the ambit of 227 is broad and pervasive. However, the High Court should not have used its inherent power to interject arbitral process at this stage. It is brought to our notice that subsequent to the impugned order of the sole arbitrator, final award was rendered by him and so on and so forth. Then, my lord, this may not be relevant. I'll take your lordships to another order. This is again from this honorable court.
If you say what is meant by arbitral process?
So, my lords, in my understanding, once there a dispute arises between the parties, some sort of a contractual dispute, to show my intention to go into arbitration, I have to send a notice to the parties invoking the arbitration clause, saying that these are the disputes, please refer them to arbitration.
Whether challenged to the order passed by the arbitrator or arbitral proceeding,
Lordship,
under the Commercial Codes Act,
Lordship,
can be regarded as arbitral process.
Sorry, my lord, I didn't.
Can be whether say any challenge,
Lordship,
to the decision of arbitrator.
Yes, my lord.
What do you call it? 34 probably is
34, yes, my lord. That is the arbitral process. Yes, yes.
Now that the proceeding before the Commercial Court,
Lordship,
whether that is a part of arbitral process.
So I'll just come to that. If your lordship just have the Arbitration Act.
Yes.
Please see section 21.
Yes. Commencement of arbitral.
Yes, my lord. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent.
That is okay.
So
But then till what time it continues?
Till the time the award is actually passed.
So it means the
By the
proceeding before the Commercial Court is not part of arbitral.
No, well, what I'm saying is the section 9 will also be termed as an arbitral proceeding itself, in my understanding. These are court proceedings. These are court proceedings. So, well, I'll just show a basic distinction between section 9 and section 17. Please see.
And it's all right. It's all right. You can proceed with your thing. See, like
What I was trying to point out was
so
arbitral tribunal is basically the court which takes up all the disputes between the parties. Now, they have the power under section 17 to pass interim orders, injunction orders and so on. But there could be instances where the sole arbitrator has met a sudden demise. He's not available, he's out of the country, he's extremely unwell. So in those situations, suppose there is a development and some interim orders are necessitated, where does a party go? That is why section 9 has been included in this act to allow the courts to pass such orders, which is why it says a party may before, during or even after the arbitral award go to the court. So even before an arbitral tribunal is constituted, I can come before a court under section 9 asking for some sort of interim relief. Now even after the arbitral tribunal has been constituted and the proceedings begin, there could be a situation where the arbitrator is not available, has expired, has gone out, something of that nature, his mandate has expired. Then where do we go? And there is a very serious pressing issue. That time we can come back to the court under section 9. So this is all part of the arbitral process in my humble submission. Now please see this judgment, Lordship. This is NEPCO versus Patel.
This 2022.
2022 SEC Online Meghalaya. So this is again by a division bench of the Yes. Yes. Your lordships have that. So here, my lord, what had happened? An ad interim order was passed under section 9 of the Act in favor of Patel against NIPCO. This is with regard to encashment of a bank guarantee. NIPCO preferred an appeal under section 30, statutory appeal. Please see para 8.
Yes.
Just to show lots of the fact, the appellant herein first refers to the ad interim order that was passed on the petitions under section 9 of the Act. And then please see para 11.
Yes.
At the outset,
Yes.
a preliminary objection is taken on behalf of the respondent. Now, this is the beneficiary of the section 9 order, the respondent, to the effect that the appeal is not maintainable. So, they take a plea that the section 37 appeal against the interim order under section 9 itself is not maintainable. A facetious submission is made by referring to section 37(1)(b) of the Act, that it is only the grant or refusal to grant any measure under section 9 of the Act which is appealable under section thereof. According to the respondent, no measure has been granted under section 9 of the Act by the order impugned. Such submission has to be rejected out of hand. There is a right and proper injunction in place, and by no stretch of imagination can it be said that the order impugned or the directions quoted above do not amount to an injunction. Even when exercise of a right is hedged with the condition introduced by an order, such order amounts to an injunction or an interim measure under section 9 of the Act. In all other initial orders, the ex parte order and the subsequent extension orders, they were all for a specific time period, extended till a particular date. Those are all interim orders in nature. Perhaps may not be appealable under section 37 in view of the judgment that has been referred to in NTPC. However, the order for restoration of or opening of the locks was not limited to a particular date. We cannot turn them as an interim order. That was a final order. That was a measure under section 9, and therefore it has to be appealable. So the question of maintaining a 227 application does not arise. Now, your lordships will see from Bhavin's judgment, which I referred to earlier, a clear distinction is made between a lack of inherent jurisdiction and between exercise of erroneous jurisdiction. Erroneous exercise of jurisdiction. We are perhaps in the latter.
Passing of the order,
Lordship.
With the passing of the order of restoration,
Lordship.
the question of restoration attains its finality.
It was not really a restoration, my lords, because we are still in possession. My articles are still inside.
What is?
Can you look at
the revival?
the
The
act?
question
Yes.
of revival.
Just to open the locks, yes. Status quo ante, if I may say, status quo ante. It's not a case where the court says file your objection. The objection is already filed. Lordships will notice. They filed a note of objection. Matter was heard right there and then. They appeared over VC. The matter was heard entirely and order was passed. So I would submit that the application under Article 227 does not raise any exceptional circumstance that requires the interference. And moreover, they gave in to the interim orders that were passed before. They were very happy with those orders. They made objections. They raised all their objections with regard to the jurisdiction of the court, the maintainability of the court and so on. Despite that the court passed certain protection, some protective orders, they did not challenge those orders.
On what ground maintainability was?
On the ground that, number one, the injunction cannot be passed in view of section 14D, 20A and 41HA of the specific relief act. No, these are questions of fact which a court have to arrive at.
There is no question raised with regard to the inherent.
No, not at all. Not at all.
Yes.
So that is the distinction here. Now they want this court to decide what is pending before the court, before the commercial court. So there are now two courts which are deciding the same issue, if I may put it that way, because this issue of whether there is a clear bar under section 14D, 20A and 41HA is pending before the court today for judgment. Would your lordships prejudice me by deciding that issue?
Right from the beginning, this court has, you see, basically made it clear, Lordship, that since the final judgment is coming today, this court will not pass any order. This will create more confusion.
So I have just gone through the entire.
In any case, whatever order comes today will be appealable, definitely, isn't it?
Yes.
So you have to, the parties, aggrieved parties will have to.
Well, I don't know. To be very honest, I don't know, because here the question of maintainability has been raised. It was already understood between the parties that if the court finds that the petition is not maintainable, I don't have locus. There was a question with regard to who's the correct party which has come before the court. In case I suffer a bad order, then my proceedings end in any case. The entire section 9 application will be dismissed, then I'll have to prefer an appeal, or I have to prefer a separate section 9. In case the question of maintainability is decided in my favor, then they'll have to prefer and invoke whatever remedy is available to them. So then the section 9 petition will still remain, because in the first order lordship will find, after the entered appearance, there was an understanding that they are not filing any show cause. And in case the question of maintainability is decided in my favor, that is when they will file a show cause in the main proceedings. That is the agreement that was arrived at between by the parties before the court. Now, as far as the other question...
Today, whether it is posted for deciding the question of maintainability or for passing...
Yes,
for
on the question of
passing final
maintainability.
order in section 9.
No. So, like I said, so if the court finds that my application, my locus, there is a problem with my locus, then the section 9 will be dismissed altogether.
Matter ends. So it will be a final order.
Yes.
But then, if court finds that petition is maintainable, then the
then, my lords, it was their case that they want to file a show cause.
No, but then that means, and in that way, so that will be, there will be no end to the proceeding of section 9.
Yes, it will carry on because they have not filed any show cause in the matter on merits. They have only raised 3 points. Only on that section 14D, 20A and so on.
But then to appreciate section 14D and all, is it not that the merit has to be considered?
Yes, my lord. The merit will have to be, which is why they've taken time to file their show cause. And my lords, I have been agitating this before the court that even to consider 14D, any of these issues, you have to file some sort of a show cause. And 14D by its very language says, injunction cannot be granted in the case of a contract which by its very nature is determinable. It's a very strange expression. And there are divergent views of various high courts. I have about 10 cases in my favor. They have about 10 cases in their favor. But they want the court to believe whatever they are saying is correct and the order should be passed immediately. Now, even that is the case. Matter was pending before the court. They made a statement before the court that they would not act on it. I took them on face value. I honestly took them on face value. It was my fault.
That is what AG is
It is my fault. It was in fact also an innocent mistake by the court. By all of us. We did not expect this kind of action. And please see what is the action here. Notice of termination. So the stay order was relating to 2 issues. The first order, that the notice of termination, the operation of the notice of termination is suspended temporarily and my possession is to be protected. But the state, what it does, it deputes people. Walk in and they throw people out.
Definitely. That is one.
This is acceptable. And we are treated as hotel occupants. Then, my lords, will see. So, in these kind of situations, my lord, the court cannot be a mute spectator. And in fact, by this order, my lords, my faith in judiciary is restored. And that should be the case for everybody. So, well, I know this is hotly contested, who said what before the court. But fact remains, my lord, I made a categorical statement in my application on the 18th, on the 19th. They did not deny that.
Right.
Please note that. That is very important.
See, whatever it is, but the impugn order, it appears that
there is no reference to that.
The court below has already taken view that you were in possession.
Yes, yes.
And definitely there is no question for this court to take a different view.
Hello.
You see, if
from the documents
appears
itself.
to be certain reason also, you see, like if there is certain reason for taking a different view also, that also cannot be ground for interfering.
Lordship.
Until and unless it is shown that these views are taken out of context or without any.
So, my lords, the documents are before lordship in their own application. In their own application, they say that so and so was in possession. We have taken over possession.
Anyway, Mr. Shan, this court has already showed its interest in this since the final order is coming today.
Lordship.
I don't think that we pass any order here.
Only 3 things, my lord. 3 things. My friend has argued 3 things. One, saying that saying that, my lord, that the order passed by the learned commercial court is final order so far as this application is concerned, and therefore appeal is first legal ground which has been taken by my friend is that this is an appealable order. What my friend says that 227 is not maintainable because the final view has been taken. That is the first ground taken by my friend on the maintainability of 227. On that point, my lord, I have to submit one thing only, that it is if today the matter is disposed of and application is rejected, whether this order will survive or not. All orders till the passing of final order get merged with the final order. This is a settled position of law. So it is an interim order deciding some rights finally.
No, you see, the thing is that the question of injunction, the main question of injunction, that will be decided by the final order.
Finally.
Now, say supposing in the middle, when this say ad interim order was in operation,
yes, ma'am.
and if there is any violation alleged,
yes, ma'am,
and the court's order,
yes, ma'am,
to revive back or
yes,
to correct the situation,
correct, ma'am,
will will it not stand at different footing, or it will be?
It will, my lord, the all the powers are exercised by all courts are under the law only. It is, we all, whether state government or my friend, we exercise power under the law only. Court is not a supreme authority or God which will do it. I'm sorry to
That
against
we
the
can
law.
understand, but then you see one thing.
So
is
now
that
the issue is, my lord, that the court has to act in accordance with law. I have to act in accordance with law.
It's all right. That is all right. You see, but then
So-
rightly and wrongly, it happens sometimes.
That they
Court passes wrong order,
yes, my lord.
but
So
it doesn't mean that that order has to be violated.
that
see,
if
if
I
certain-
violate, may not, I have to satisfy your lordship on the interim, whether there was an interim order, because my friend has questioned that there was interim order.
See what we say, the finding recorded by the
Learned,
in the impugn order.
yes, my lord.
This is something. These are all see like concerning facts.
Yes, my lord.
This court cannot substitute that view.
I am not asking your
Even
lordship
if
to.
you say, you see, just because another view is possible, that cannot be
No,
ground.
that can't be my argument also. I can't argue that if one possible view has been taken and your lordship has the other view, lordship substitute the view. That cannot be my argument, and that has never been my argument also. my lord.
No, we are not saying that thing, but this is factual part which
I'm
basically
so now
Mr.
factual.
Shen has pointed out
Now
about
I
the court's impression.
yes,
You see, and that these
your lordship is
about the possession of the party.
yes, my lord. So now the question which falls for lordship's kind consideration is that the courts will form certain opinion, which is not put in the order. And if the court was of the opinion that there was an undertaking, court would have said so that there was oral undertaking. Where is that line in the order?
See, is it not enough? You see, like if come
I
to that
kindly
part
see
of
the order.
case,
That is why I wanted to show the order, my lord.
come to
Kindly.
page 223.
Sorry, which page, my lord?
Page 223. of
223. Yes, lord.
your- Come to the last part.
Yes, my lord.
This is observation by the
Yes, my lord. Yes, my lord. 220.
page 223.
Yes,
220.
I'm sorry. I got it, my lord. I have perused the annexes. This is the paragraph your lordship referring to.
Yes.
I have perused the annexes filed by the OP. From documents annexed by the OP, it is apparent that petitioner was still in possession. No dispute, my lord. Petitioner was in possession in the morning. I am not saying that he was not possession. Till the morning, it is also apparent that OP has proceeded to take possession and sued promisor on the basis of so and so opinion dated so and so and take the possession while later number dated so and so. It is not an
Come to the next page then,
yes, my lord.
and then page 225 to see the last part.
Yes, my lord. Kindly
This
see.
court was under impression that
That now the question which falls for your lordship
Now-
kind consideration is this.
the court has drawn some impression.
The court has drawn
Maybe
some.
on the basis of certain materials, or may not be without.
Yes, it is possible.
Which
Now,
we will decide it here.
no, I am not asking your lordship to decide based on some material or no material. What my proposition before your lordship in law and fact both are that if the court says that I have formed the impression that we will not disturb the possession of petitioner. This is the plain and simple the order of that. The court has formed the impression that I will not disturb the possession of petitioner. That is the impression formed by the my lord. Whether on that basis order can be passed to give the possession back to the petitioner, my lord, it is permissible in law.
Why not?
No,
Why not?
now I'm answering. I'm answering that.
Order has to be respected.
No, I will.
And the
I have
court
got
should do
umpteen
everything to
respect.
see
I
that
respect.
its order is implemented.
No,
Why
your
not?
lordship, respect is not. I have got umpteen
The court
respect.
must see that its order is also implemented.
Yes, my lord.
And it is followed.
If there is an order, I will follow. If I don't follow, your lordship has rightly observed, I will be put to contempt. But
That
your
is-
lordship,
that is one thing, but then put to contempt means that order should not be implemented.
no.
Order
If there
also
is
has
an
to be
order,
implemented.
if there is an order,
Contempt is one part and the
yes,
implementation
my
is
lord.
another.
What is transpiring in your lordship's mind is this aspect, which I must satisfy. That if the court was in impression and based on impression, it has passed the order. Whether that impression can be dispelled by this honorable court in 227.
No, even in revisional jurisdiction, not only 227.
In revisional jurisdiction. Now the question which falls for lordship kind consideration is that tomorrow, learned district magistrate or learned district judge says that I have formed the opinion that the possession will not be disturbed in a private matter, and then the restoration order is passed based on impression. Is it permissible in law? Is it permissible? My question is, we are all, and that is why I showed, my lord, the law on this point that
The
and the remedy in
orders passed prior to this.
yes, your lordship. I am grateful, my lord. Kindly see the orders passed before this. I have.
There were order. Just a minute.
Yes,
There were order the restraining him to take over these things. It was extended from time to time.
No, my lord. What my friend has been praying that extend it till the disposal.
It's okay. We can understand. You have pointed out. You have pointed out that there are orders by which that was not specifically extended.
And it was not.
Now, say supposing if the court under impression that you would not take any coercive steps, doesn't extend it.
This my humble submission, my lord. This is taking us to a realm of conjecture and surmises, where my humble, your lordship, kindly see 1, 2, 3 orders. Why I have
anyway, Mr. Kumar, you see, like probably this is there will no end to it. We will do one thing. We will not entertain your application right now. We will say that since the final order is coming today.
I'm only saying,
Let's have it on Monday then.
I'm only saying, my lord, that and I have to meet 3 things which my friend has said, that appeal will lie against this order. 1, second, what my friend says, that 227, that aspect I have to convince your lordship and persuade your lordship on that aspect of the matter. 227. Second, my friend says, my lord, that 227 is second. There are certain orders which there is no rebuttal by me, or regarding some impression, etc. If your lordship will see to only to that extent, why I am taking your lordship to that extent, your lordship kindly see. Page 173, your lordship. Because chain of events will make it very clear, my lord. (174), if your lordship will see, 25th March 2025 order.
Which one, sir?
124.
Page 173.
74, your lordship, may kindly see. Because that aspect your lordship has already seen. 174, my lord.
Yes.
The appearance has been put up, my lord, and 4th paragraph. Learned counsel, the respondent, petitioner both submit that learned counsel respondent has touched upon the maintainability of application under section 9 of which will have direct bearing on commercial arbitration number 2. So this is an admitted position. It's not that it has no bearing on the main petition. What my friend has argued that it has no bearing right now. Right now, both submit.
It is not that. Mr. Shan has basically said that your objection is not on the basis that you raise the question of lack of inherent jurisdiction.
Your lordship, kindly see this line. Kindly, learned counsel for the respondent and petitioner both submits that learned counsel for the respondent has touched upon the maintainability of the application under section 9 of the arbitration, which will have direct bearing on the commercial arbitration number 2. Learned counsel, the petitioner have made suggestion that the issue of maintainability as raised by respondent may also be treated as part of the main application. Learned counsel for the respondent submit he has no objection to proposal made by the petitioner. However, submit even if decided the application is maintainable, he would have reserved the right to reply in the application under commercial. As agreed by the parties, issue of maintainability is taken up for consideration together in so and so an instant case. However, in the issue of maintainability is decided in favor of petitioner, respondent would have liberty to file reply in the main matter. Learned counsel has prayed for extension of interim detail the matter is disposed of. However, this has been objected to counsel in the interest shall not take coercive till Thursday, my lord. Now kindly see the date on 20.
So you have taken us to all those things.
No, my lord, that aspect, no, this aspect,
what you are
that aspect I have not touched. What my friend has said. Your lordship will see my appearance is there on 25th, 27th, my lord. Kindly see 27th. Last paragraph, my appearance is there. Extension of till the disposal. However, this has been objected to learned counsel. I appeared, my lord. Mr. Pandey appeared and objected to on 27th February, my lord. Now for 28th February, my lord. Now 28th February, I have then 28th February. There is no appearance on my side, my lord. My only.
No, see, ultimately it is coming to that. You are challenging that very observation recorded in the.
Exactly.
You are trying to dispute it. See,
I'm disputing not on the basis of impression, on the basis of record. We are all code of record, my lord. We have to go by code of record. If tomorrow, if your lordship will permit, my only difficulty, your lordship will permit that in the code of record, if the impression will have the overriding effect on the code of record. Under Article 129, my lord, your lordship is, we are code of record. The district court may not be code of record, but ultimately if on the maintainability, with my friend says that it is a main issue, let the maintainability be decided first. If the maintainability is decided in my favor, he will have the other remedy. If and against me, I will have other remedies in law, my lord. So maintainability became core issue.
That we can understand. That is
And
right.
what
So
my
there is no
say,
dispute to it.
and then therefore what lordship is saying, that in the impression, if my friend is saying revive the order, he was, suppose I have taken the position, my lord, for example, before after termination I would have taken the position. What is the remedy in law which he will be having? A remedy in law that he will file a suit for recovery of position, or he will go to arbitrator?
No, my lords, absolutely not.
The-
The courts have the power to mold relief
and
under
before I
151
take, my lord,
restoration
because
position is
the
absolutely
law,
permissible.
we have to go by law, my lord. Law is that if you say that there is no stay operating, there is admittedly there is no stay operating. If there is no stay operating, my lord, tomorrow if the court says that I have found the impression in my home and in my chamber, that there will be nothing will be done, my lord. That is the oral order which your lordship has taken. That is why I take your lordship. I knew that this is going to be the argument, my lord. And that is why I took your lordship through the judgment of the Honorable Supreme Court, that based on oral order also, even if there is an order by this court, orally also. That's a question which is falling for your lordship's consideration, my lord. So therefore my submission is, my lord, that the order, if on the face of it, is against law, because it on the base, first I am having possession, second there was no interim order, my lord, third, in exercise of section 9, what power you are exercising under section 9, because I have shown the judgment, my lord, even constitutional court would refrain from exercising.
Even if there is no injunction order in operation, can you go and throw?
Yes, my lord. That's a very pertinent question which your lordship has put. Whether if no injunction is operating in,
especially in a pending matter.
Yes,
Here,
no, in a pending.
Technically,
Yes,
you
my
can
lord.
make many differences. But then, if a matter is
There are
pending,
many shades. Your lordship is right. There are many shades to this aspect of the matter. There are many shades. What I say, my lord, as on today, because if the what I say is that the matter has to be heard and finally decided by either your lordship or by the trial court, my lord. But my rights are as on today. What they say that you give, is this kind of order could have been passed by the learned commercial court, my lord, on the basis of impression when the records says otherwise, my lord.
it's a kind of, you see, restoration of status quo ante. Why this court cannot pass an order of status quo?
Your lordship
restoration
can
of
pass
status quo
all orders, my lord. The question is that your lordship can pass all orders. My endeavor is only to show that your lordship will pass order as per law. Your lordship's power I am not questioning at the moment.
No, there is no question of power here. It's not coming. You see, even for a trial court, say like for a civil court,
yes,
can't it pass an order of status quo restoration?
Yeah, lordship will, the court can pass the order in accordance with law and accordance with the section 9 ambit, my lord. Without that, it can't pass the order. That is my submission.
No, what is according to section 9 or not? That is yet to be decided.
Yeah, lordship. Then before your lordship, my question to myself is.
See, Mr. Kumar, one thing is that we are in 227.
Yes,
so until and unless what we say it is like there is a gross error of law.
Yes, my lord.
There is
I bow down. I bow down. Your lordship's examination.
Now, so far as the question whether section 9 petition is maintainable or not, whether the commercial court has the inherent jurisdiction, inherent lack of jurisdiction or not, that is not very clear at this stage.
Yes, ma'am.
So probably no case has been made out.
No,
for interference, causing interference at this stage.
The question which lordship has posed to me, that under Article 227, only in the cases of inherent lack of jurisdiction.
No, not only in. See, the
all right. So in case of
gross error of law.
Gross error of law.
Now, what is gross error of law and what is ordinary error of law?
Yes, my lord. That is the question which is posed by your lordship, that whether the 227 remedy will lie only when there is a gross error of law, not in the case of ordinary error of law. That is the issue which is. Now, if I say, my lord, that the section 9 confers jurisdiction on the commercial court to grant interim measures, that is not in dispute. It is also not in dispute that what kind of interim measures can be granted under section 9. Whether your lordship is saying, no, the determinable contract, my friend is not disputing that it is a determinable contract. My
No, I'm
friend is.
disputing this,
It
absolutely
is.
disputing this.
My friend is not disputing.
Whether,
No, no, I'm
whether,
disputing that.
tell us one thing, whether this court can decide the issue whether it is determinable complaint or
No,
not.
I'm not for that purpose. The purpose
So
is what.
until and unless these are there, how this court will decide all
No,
those things
I'm
here?
not asking. What I'm trying to say, I'm sorry, I couldn't make myself clear. Point is, my point
Probably
is.
you have made it clear. The court is not understanding.
No,
Yes.
no. Point is, because this is a journey where we have, this is a discourse which we have to take and we have to follow. The point is, my lord, in any besides this example, where a court takes a view which is against the law, which is against statutory provision. Now the question which will fall for your lordship's consideration is that view is within the jurisdiction, error within jurisdiction, or error outside jurisdiction. Infra petita or ultra petita, this is a concept. Error within the jurisdiction is permissible, because your lordship will error within the jurisdiction, because I was conferred with the power of section 9.
What is error outside? Error outside,
Outside means that
question of error outside jurisdiction doesn't arise.
No, in this
Because
now the question whether is a case of error within the jurisdiction or case outside the jurisdiction. Your lordship says that it doesn't arise. The error outside jurisdiction.
See,
is
outside jurisdiction is something.
For
where
example,
the court has
the
no
criminal
power
court
to
is
travel,
criminal
to
court is
venture in.
deciding the section 9 application. That will that would amount to error.
See, Mr. Kumar, your objection which you have raised on the basis of provisions of specific relief act.
Yes, my lord.
These are all to be determined. It has to be determined.
Well, that's in fact pending before the court.
No,
we've already
All
concluded
have
our
to be
arguments.
determined, and this court cannot go for determination of that.
I'm sorry, my lord. I'm not asking your lordship to go into that aspect. That
No,
aspect.
but then if you say
What
that
I'm
jurisdiction
saying-
has to be decided on the basis of provision of the specific relief act, then this court cannot undertake that exercise.
I'm not asking your lordship. My endeavor was limited only to the extent, to the extent of showing that what my friend is saying. My endeavor was only limited to the extent in showing that the exercise of power, if it is against law, then 227 is maintainable. Because that issue is pending. How can I ask your lordship to decide, go into if it is against the law, prima facie, on the face of it, the 227 is maintainable, and two reasons are there. Because that
please repeat it again.
If the decision rendered by the inferior court is against the law, then the Article 227 remedy is available. I can
against the law is something.
Yes, my lord. Now the question
different.
which
You see, if the exercise of jurisdiction is without having any inherent. You see, sorry, that is if there is a lack of inherent jurisdiction.
I beg to disagree. My submission is, my lord, that 227 remedy is not only in those cases where there is a lack of inherent jurisdiction.
Lack of inherent jurisdiction is one of the example.
One of the example, my lord.
Gross.
Yes, my lord.
Error of.
If you lordship kindly see the judgment of.
This is one of the aspects.
No, 1997, and I have got compilation.
That is all right. This is all right. You have, Mr. Kumar. You have given all those things.
Yeah, kindly see. No,
Then have it on Monday. We'll see what happens today. In case my application is dismissed, then there's no need for any further discourse.
That is also one.
Lordship, then in that case,
have it on Monday or Tuesday as per your lordship's convenience. We can come back with the judgment as well. Because what happens once if it's passed on sometimes, in fact, that's the case here. The orders are not uploaded. There's a great difficulty. The court is a very busy court.
Your lordship may have it on Wednesday. Then in Wednesday, in the Wednesday. Only thing is, my lord, if I can pass on the judgments for 227.
You can give, but then Mr. Kumar, I do not know. This court also has to digest all those.
Yes, my lord. No,
as this has, you see, openly, these are probably new subjects.
These are contentious issues, my lord. The view has been taken by this is the judgment we have relied before justice.
You have given so many judgments.
Yes, no, 227 specifically, my lord. Compilation is there, where in this case, my lord, I was give me that judgment. The Against Arbitration Act, my lord. Yes, my lord. Sorry, this is the judgment which was upheld because I challenged it to the Supreme Court also. This please give the judgment. No, there are two judgments. Yes, your lordship, there is one more judgment of justice. Thank you only. on this issue of maintainability of 227. Similar. Arising out of, Your Lordship may have the judgment, and we will try to persuade Your Lordship on Wednesday on this aspect of the matter.
This Justice Sankey's judgment is.
Yes, he has rendered so many judgments on 227. In fact, we challenged this judgment of Justice Sankey in Honorable Supreme Court also, and we lost on the maintainability of 227.
Yeah, actually, this is a slightly different case.
Supreme Court matter becomes more tough.
Lordship, have it on Wednesday.
Very tough.
So, Mola just hard. I don't know the
Yeah. Which one? Which one?
I'll send to you.
Mr. Kumar.
So, ये आपका है.
I wish to extra copy.
ये मेरे पास है.
And also Mr. S. Chan at some length. The present application under 227 is preferred against order dated 19/3/2025, passed in commercial miscellaneous case number 1 of 2025, arising out of what is that? Arising out of commercial arbitration case number 2 of 25. Wherein an interim where is that 19/3 order is
at page 222, my lord.
wherein the petitioner was directed to remove block and restore the suit property to the possession of the petitioner. Stop. It appears on the record. The order 319/3 is passed basing on certain other orders which were passed previously. Certain other orders passed previously by the same court. You have not filed your response to the prayer for intent. Only you have challenged the matter.
Orally, yes. Yes.
They agreed what has happened, my lord, in proceeding that it was agreed that on the basis of that, and then if my maintainability is rejected, then we will be given liberty to file.
Today the court will be deciding the question of maintainability.
If maintainability is decided in my favor, so then they
then
will
the-
have to file, and
if
if it
that-
is their favor, then we'll get the opportunity to file reply to the main
But
petition.
then in say supposing if it is in your favor, that's fine, matter ends there
Yes.
probably so far as things
Yes,
are concerned. But then if it goes in their favor,
yes, my lord.
then this question of interim will again remain open.
Yes, it will be open, my lord. It will be before your lordship.
Yes.
It will be open.
Just it's okay. It's okay. It is submitted by the parties after it is submitted by the parties. That maintainability to the orders, or they have challenged the entire proceedings.
No, not only because that is the only order which is other orders. So there is no order because they want section 9 matter is being heard.
Maintainability of case number 1 of so and so, and what is that order where you shout your submissions?
That 170, 1 minute, that
170 something.
176, and then
So 19, sorry, not 92, उसके बाद वाला. नहीं, ये सही सर.
the order, my lord, is injunction granted on That is at page 175. And then thereafter submissions have been recorded.
Yes. Yes. Maintainability. What is it? The learned counsel ransom is about to submit the maintainability of the contingency of the application under section 9 of the Arbitration Act. Section 9 application is the one. So this thing, this commercial miss case number 1 of 2025 is
This case is basically an ad interim application for ad interim relief.
okay. So this is means like in the matter of interim nature, there is another interim application. Section 9 itself in the
interim, yes, Miller.
Okay.
As abundant precaution, we had to file.
Say the proceedings before the party submit that the proceeding, the maintainability proceeding before the commercial court is under challenge, and the question of maintainability is already, and the argument on the question of maintainability is already been heard by the court, and it is pending for passing of.
And it is fixed for today for orders.
Today for orders. And it is fixed for passing of appropriate orders. In view of the submission. Now, since the passing of the order on the question of maintainability may have some bearing in the present proceeding, let this matter, comma, then you say as paid for by the parties, comma, let this matter be listed on
Wednesday.
Wednesday.
26th for consideration, for further consideration, for further hearing and consideration.
Grateful, Miller.
It's a very difficult job for the court.
Very difficult.
Especially for this court.
For us also.
No, for us though it's okay. But then if a person, if he doesn't know alphabet, how he will read the sentence and words? Anyway, thank you for
Item number 4.
send this file to my room.
Lordship, this matter may be listed after 3 weeks because a connected matter is pending before DB, Your Lordship.
These are all those.
Yes, Lordship.
This is
So after at the time of
this has
incident.
come for the first time.
No, yes, first time, Lordship.
Let the notice be issued.
Lordship.
Notice has not been issued.
Yes.
Not yet.
Yes.
What is the case? We should know at least.
Yes. The case here is that at the time of they were both a private respondent and the petitioner, they were in relation, love in relation.
This is a POXO.
Yes,
arising of
POXO.
matter.
Much less, Lordship.
What is there? Any matter? You are ready?
Your Lordship, in this matter, this is item 1 of the main list, Your Lordship.
Yes.
Your Lordship, in this matter, it's just a small issue where instructions are to be brought by the government advocate.
Yes, Lordship.
Your Lordship, it has been pending for 1 year just for instructions, as per the order 18-3-2024.
By the next date, Lordship, we will.
What is the nature of instruction to be taken?
Lordship, this is pertaining to reservations.
18.3?
18-3-2024 order sheet, Your Lordship.
It's already 1 year for
Yes,
taking.
Lordship.
1
The
year for
petitioner
instructions, Your Lordship.
is in the disabled category. This case is pertaining to there was a vacation in the lower division assistant LDA. So there were 2 posts. So in one post, the petitioner is claiming that he fulfills
in one post,
criteria.
appointment has been made.
Yes.
And the other post,
Your Lordship, at first there were 59 posts which were selected. 59 candidates were selected for the post of LD. Only from the 59 candidates, 1 was appointed under the
54.
reservation of disabled. So, Your Lordship, after that there's a 2000.
all these 59 posts were not meant for disabled person.
No, Your Lordship. Out of these,
that,
it was 3%. 3%. So out of 59.
how much after? If you take 3% means how many?
It'll be one. However, Your Lordship, there's a notification 2017 before the result was declared. In this notification, it says that it's 4%. So if the percentage goes up, so
the number of posts also.
Number of posts also as per the for the disabled.
Okay, that is reflected in order 18.3.
18.3, Your Lordship.
Yes.
So for that reason, Your Lordship, they are to seek instructions on this notification.
Mr. Thaba, this is very unfair that you take so much of time for taking instruction.
Yes, Lordship, we have been trying it time and again. There seems to be a delay.
No, if your officer doesn't respond, then tell us. We'll bring them there. You tell us, you make a submission, then they are not responding. Have you written to them?
Yes, Lordship, we have done that multiple occasions.
Please remind them, they are bound to respond to you. Yes, if required, you can summon them also to your office. You should use your authority.
We will try one more time, Lordship.
Your Lordship, let this be a last chance, Your Lordship.
We'll give them another opportunity. If this instruction is in your favor, then we can close them without going into other
instructions.
This Mr. Thabal Anil appearing for the state respondent has sought for grant of further time for obtaining necessary instruction which was required upon him to be taken by virtue on the basis of order dated 18/3/2024. Stop. MS
B Kharwanna. BF Kharwanna.
National Council for the petitioner has objected to the prayer and submitted that on many occasions the state has been granted time to take instruction. Stop. However, for the interest of justice, the state respondent is granted further 2 weeks time for obtaining necessary.
Yes,
Lordship. What role you have here?
Your Lordship, the private respondent here is from the disabled category.
Okay.
The private respondent comes under the 3%.
So you challenged their
We challenged on that ground, Your Lordship. Now, after we came to know about this notification, Now our prayer has changed to the part where like, we will also be included under the 59.
So you have withdrawn that challenge?
We have not,
No, not withdrawn.
not formally yet.
But then you are not pursuing it with the same strength. You have. Okay. This after 2 weeks. Any other matter?
Elio Raj.
Elio Bench.